Hear ye, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now say the Commonwealth of Massachusetts, court is open, please be seated.
Good morning. Welcome to the September 3rd, 2025 sitting of the Massachusetts Appeals Court. I'm Justice Eric Neyman. To my right, Justice Joseph Ditkoff. To my left, Justice John Englander, and we will be your panel for all 6 cases this morning. Usual appeals court rules are in effect, which means each party has 15 minutes to make its presentation, to make its argument. There is no rebuttal. I assure you that this panel is well prepared. We have read your briefs. We understand the facts of the case. So please cut to the chase and get to the heart of the argument. Calling our first case, docket 24P1035, Commonwealth versus LARIVIERE. We'll hear first from attorney for the appellant, Attorney DeMaio. Good to see you, sir.
Good morning, Christopher DeMaio for Matthew LARIVIERE. So on the jury instruction issue, we're arguing here that the jury instruction given, which is apparently the model instruction, as the Commonwealth points out, didn't fully encapsulate the law in this area as the SJC has described it in the cases we cite, Torres, Carlino, and Little. And the law is that a self-defense is defeated by, where showing that there was excessive force and, quote, death resulted from the use of excessive force. The instruction here definitely talked about the use of excessive force, and it talked about Mr. Jones dying. But what I would suggest is that when you, even taken as a whole, and you're supposed to read jury instructions as a whole, we realize there's nothing in the whole instructions on self-defense and on manslaughter and murder from which you would suss out that there's this causation element that the...
I take it you can see that this is what the model instruction, that they gave, the judge gave the model instruction.
It's true, yes.
Right?
And it's a substantial risk. There was no objection, presumably because it was a model instruction.
And when you quote, death resulted from the use of excessive force, which case says that?
So it's in the Carlino and Little cases. It first appears in the Torres case sort of as a dictum, and then it's picked up in those cases. Our argument here really is that...
Has there been any case that's turned on this?
There are no cases that have turned on this, actually.
In Massachusetts or elsewhere?
I didn't look elsewhere, but I didn't see anything in Massachusetts that turned on this. Actually, I may have looked elsewhere. I may have done some limited research, but nothing. I'm not aware of any case where this particular issue has come up.
As I understand your argument, it's that there is the possibility, for example, that the first stab wound of the 137 stab wounds could have caused death of the victim here, and that in effect the other 136 blows could have been, for lack of a better term, surplusage.
Yes.
Was that the argument made at trial?
Well, that was not the argument made at trial, but that particular hypothetical isn't really something I came up with. It's Dr. Hall, the medical examiner, was asked when she was cross-examined about, well, you don't know how many knives were used and you don't know which blow came first. And she sort of sua sponte said, I don't, if the first blow had been to the heart, he would have died sooner. I don't think she said immediately, and that's kind of common sense.
But she also opined that the cause of death was multiple stab wounds.
She did say that too, right. Which I take.
So to get back to my question then, what was the specific evidence in this case, beyond speculation, that death was or could have been caused here by one initial blow?
Well, because she said that he was, in addition to the various blows to the limbs, that there were blows to the heart, the lungs, and other vital elements. And she gave that example. I agree. I can see that she also said, you know, on the death certificate, she wrote multiple blunt force, sharp force injuries. But that was her example. And at a certain point, I think the jury can use their common sense. If the first blow is to your heart, then it seems to me Mr. Jones was he was going to die very quickly at that point.
Well, I thought Dr. Hall testified that after the wound to the heart, it could be several minutes, a few to several minutes before he died.
No, my memory is she said it could have been a few to several minutes before he died, but I can't tell you exactly because I don't know the order. And then she gave the example of the heart and said that would have been sooner.
He would not live as long if the heart injuries came first, but aren't we still talking about minutes to die?
I don't know. Well, I quote a case in there which says minutes to die, which I don't remember any. I don't remember any evidence that it took minutes from. My understanding was she didn't know because of the state of the body, the decomposition, and just wasn't able to say. But yes, I mean, if I guess my point is there's a causation element, so there would have been an issue for the jury. The argument could have been made that if he was, in fact, if Mr. LARIVIERE was justified, if you credit what he said, that this guy came into his tent in the middle of the night with a knife, and he can't escape from his tent like you can from a house if he wanted, so he has to fight his way out. Then in that case, if he was justified in making some kind of defensive stabs to get away, then one of them might have been to the vital organs that she discussed and fatal. I guess from my perspective, if he's fatally wounded, then it wouldn't matter. I'm not arguing that he lost consciousness immediately.
Why is that? I mean, if you come across someone who's fatally wounded and you slit their throat, isn't that murder? When you shorten the remainder of their life?
I mean, all right. From my perspective, this is, I would say, akin to the cases where it's one series of blows, like you have in assault cases, where it's simply one activity. I mean, if Mr. Jones had lived, I think this would have been one assault and battery with a dangerous weapon case and not 137. Maybe I'm wrong about that, but my point is that there is certainly an argument to be made where there were injuries to the vital organs that causation was in play. I'm not saying at all that the jury might have said you stabbed the guy over 100 times, you're not walking away scot-free. So this isn't by any means a Lattimore type of argument. It's an argument that there seems to be a gap in the instructions, and it could have made a difference because it seems to me causation was not a shoe, and it is their burden. The questions from the panel are about what evidence was there that there was no evidence that I'm aware of that.
I didn't mean it's a reasonable. I think it's a reasonable inference that he didn't die from the 137th blow. Let me ask you this, because I'm troubled by the process here. You're asking us to reverse a manslaughter conviction where the judge didn't do anything wrong. What did the judge do wrong? The judge was not presented with this argument. The judge was not presented with an argument as to what the instruction should be, which is sub B of this question, which is, it seems to me, critical as well, and I'll ask it in a moment. And he gave the model instruction.
He did. Yeah.
So you want us to reverse a manslaughter conviction where the judge didn't do anything wrong. We review for error. So that's my process problem over the top, and you can talk about that, but the first thing you have to answer is, what should he have instructed?
Well, I think he should have instructed it's around pages 109, 110, when he's talking about how self-defense can defeat a murder charge, and when it's imperfect, he should have used that language that I quoted about death resulting from the use of excessive force.
And that death must result therefrom?
Yeah.
So just those words?
Words that import the causation, that if the 137th blow is not doing anything, that there's no causation, and that's not relevant to whether it defeats the self-defense. The judge didn't. I agree. I concede that no one put the judge on notice. It's sort of an obscure issue that came up on appeal. But I mean, that's generally
well. If it were truly obscure,
sorry.
If it were truly obscure, I mean, we're reviewing for substantial risk of a miscarriage of justice, and if it were obscure, I think that would be it would be hard to say there was a miscarriage of justice. The problem here really is that the 137 blows were emphasized over and over and over again, and perhaps the jury should have been told that in order for excessive force to be the basis for avoiding a murder charge, that the excessive force has to cause the death. In other words, if he died after 3 blows, the next 134 aren't relevant to that defense, right?
That's the argument, right? And yeah, it's a substantial risk. I mean, it seems to me I've had cases before where a judge gave instructions that were correct at the time, but there was a substantial risk because it was decided after the fact that something was missing. And that's really the argument here. We're certainly not faulting the judge.
What's the standard? What's the substantial risk standard you want us to apply?
Well, it's the substantial risk standard is where the court has a serious doubt that the result of the trial might have been different. It seems to me you have to have a doubt, at least, now, whether it's a serious doubt, but that there's basically an element of the self-defense that was omitted, and it was on causation, which seems to me not a shoe-in for the Commonwealth, although certainly they might have won on it, but that's our argument. That's the substantial risk standard.
The standard is whether there's a substantial doubt that the result of the trial might have been different?
Serious doubt is what I wrote down here.
Doubt?
Yeah.
That's from Desiderio?
That sounds right.
Okay.
So I can move on to the closing if the court wants, or if the court has questions on causation.
Go ahead.
All right. There's a lot of, we talk about a lot of things in the closing argument. I don't want to go through them all, and I won't have time. I do want to mention the point about whether more than one knife was used, because I think it's an interesting issue. The Dr. Hall, the medical examiner, said it was possible more than one knife was used. She couldn't say how many, in part because the body was decomposed. And then in closing argument, the prosecutor urged the jury that they could make the inference that more than one knife was used. And I would submit under the Buckman case, which we cite, which is a case about DNA, that was improper. And I would argue just generally that when a party puts on an expert to talk on some expert topic that's sort of beyond the ken of the average juror and says, I can't, such and such is possible, but I can't say one way or the other, then it's not reasonable for lay jurors to be asked to draw that very same inference that the expert said, the evidence is inconclusive, right? It's possible, I don't know. So that is the knife issue. The other one, the argument that Mr. LaRiviere was robbing Xanax from Mr. Jones seems pretty far-fetched to me. There was testimony that he bought Xanax from Mr. Jones. But to get from that to robbery is a stretch, and I would refer the court to the Lamrini case, L-A-M.
I thought the defendant testified that he actually took the victim's phone.
He testified that he claimed he was going to call the police, and he couldn't unlock the phone, and he threw it in the woods.
And he took his bags too, right?
Well, that was a little unclear. He said he found the bags at some point in the woods,
Could a jury so infer?
I picked them up on the way.
Right.
That's what he testified to. So
Right.
it's not the strongest argument, but why can't you infer from those two that he actually did some robbery?
But it was argued as a motive. It was argued he murdered Mr. Jones to steal his Xanax. The bags, as I understood the record, they weren't on Mr. Jones at the time, so I don't think that could be the hook to make that argument. The only hook I see is he did it. He concededly bought drugs from Mr. Jones, but this is pretty thin. In the Lamrini case, it seemed to me there was more. There's argument that the victim had less money than he had earlier in the day.
What about so one of the things I don't understand as well is two gentlemen to my right is context. What about the emphasis on, you know, the horror of the scene after the fact? Aren't there cases that say that prosecutors overstep their bounds when they talk about these things? Is this because this is tried as a first-degree murder, extreme atrocity, and cruelty?
Well, I assume so. I mean, that's how I read it. And
But so the context of the trial is it's tried as a first degree based on extreme atrocity and cruelty, right?
Correct.
And under the case law on extreme atrocity and cruelty, do things that you do to the body after the fact, are they relevant?
One of the factors, I think, is whether you use more force than necessary. So that's why I didn't make an appellate issue.
More force than
Clearly-
necessary
clearly-
to cause death, or more force than necessary overall?
Well, I think it's that's the KINNON case, I guess, and I read it to be causing death. That's why I didn't make an appellate issue of the 130. Clearly, they harped a lot on the 137
And
blows.
on
I mean,
maggots
but
around the body
yeah,
and all,
exactly.
you know, all the rest of that stuff.
That,
And I think I know that there's case law going back 40 years that talks about, you know, there's a case about, look, he's a piece of charred meat.
yes.
And the SJC, they reversed on that.
I believe I cited some of them in the blue brief at least. So yes, so that was over the top, as we say in the brief, in my opinion. It was more than, certainly it's, the Commonwealth has argued its consciousness of guilt, and certainly it was fair to say, did Mr. LARIVIERE act like someone who'd, you know, was justified in killing? Look, he didn't call the police, he went and hid the body. The body was in the woods in August for 3 days. That's fair, but yeah, the maggots and lying by the trash pile and so forth was improper.
Okay. Thank you very much, Attorney DeMaio. Excellent argument. We will now hear from the Commonwealth.
Good morning. May it please the court, Steve Nato on behalf of the Commonwealth. Beginning with the instructions, obviously they are supposed to be read as a whole in their entirety. And here, I think it's significant that the judge, as the model instructions do, began with self-defense, the instruction in general terms. And here, in this case, the only instruction involved the use of deadly force or the fatal force at issue. As well, the parties, I think, at all times in this case seem to treat the stabbing here as happening quickly in a single incident. I don't believe there's a defense theory trying to tease those individual wounds.
Well, that begs this question for me. Assume the same facts, except the defense called an expert. And that expert testified to the effect that it is my professional opinion to a reasonable degree of medical certainty that the first blow caused death, and all of the other blows were post-mortem. In that situation, must or should the Carlino instruction be given?
I think it would be heavily fact-dependent, depending, hard to say, maybe, I guess, is my answer.
Go by the facts I just gave you. Let's assume that the medical expert testimony was appropriate, relevant, and admissible. In the hypothetical I just gave you, should the Carlino instruction be given? If so, why? If not, why not?
I suppose in that case where it would still all be one kind of sequence use of force, I would say maybe not. And under the logic of this New York case I cited in a footnote, Darden, which had multiple gunshots, although I acknowledge there, the court says there was no one could say that any particular gunshot was inflicted post-mortem.
But if that's the defense theory of the case and there's evidence to that effect, if the proffered instruction isn't given, doesn't that create the situation that Attorney DeMaio is contemplating, which is the jury could have found that excessive force was used, but it did not cause death, and yet the defendant's still convicted of manslaughter? Wouldn't that lead to an improper result in the scenario I just gave you?
again, perhaps maybe an instruction that that's something they can consider, but again, perhaps they could consider the other way, that all these stabs were, even if the first one was the one that did it, it was a flurry of blows that happened sort of in a single incident, that a jury could perhaps look at that as the use of force, or they could go the other way. And
I mean, I'm not asking you as an academic exercise. I'm trying to figure out that if this scenario is truly given, let's assume in a less extreme case, let's assume it's 5 step, or let's assume the hypothetical that Attorney DeMaio proffered in his brief. Someone is shot with a gun and then stabbed several times. In a scenario like that, if there's evidence, not beyond speculation, that it's the first blow that caused death, should trial judges give something equivalent to the Carlino instruction?
Probably. I mean, I believe the Carlino case and the other cited that the excessive force must be what results in the death, or what causes the death.
But, I mean, and doesn't that make sense as a matter of common law? So, you know, take a situation where, just change the hypothetical to this. Jones attacks the defendant in his tent. Just assume these are the facts. He attacks the defendant in his tent. The defendant reasonably needs to use deadly force to defend himself. Say he has a gun. He fires a shot. He kills the guy. He's pissed. He stabs him 137 times. It's now manslaughter. His act was justified. Now becomes manslaughter because of the event after the death? Is that what the common law would say?
Well, I think that's again, a different thing. There's clearly one.
No, I know I've changed the facts from what you would say they are, but I'm trying to get, as Justice Neyman was trying to get, to what the law should be here.
In that case, perhaps such an instruction is appropriate. I'm just not aware of any.
Well, but then the question is, shouldn't that instruction have been appropriate in this case, where we don't know whether it was the third stab wound that he left a knife in the guy's neck and the guy's dying, and then he's angry and he stabs him another 134 times? We don't know, right?
Well, the testimony of the expert was that it was multiple wounds to the multiple, or I think it was
hence my use of the word third.
In her testimony was that they contributed to his death. So this simply is not a case where I think that is really an issue. And again, I refer to
Is that true? I mean, let me read to you what the judge said to the jury. He said, now when I use the word proper this is right off the top. Proper self-defense, I am distinguishing self-defense that is both justified and proportional, and therefore a complete defense to the crime, from self-defense that is justified but where excessive force is used. Now, if I'm a juror, I'm thinking 137 stab wounds sounds pretty excessive to me, unless I'm told that it has to be excessive force that causes death. Maybe I just think, well, you know what? The law is, if he uses excessive force, it's manslaughter.
And again, where the instructions begin with the use of deadly force, and that's the only force they're instructed on, there's no non-deadly force issue here, then proceeds into the murder section where he has to prove that, the Commonwealth has to prove that the death was caused by the defendant by this deadly force that they've been, focused in on at the top, and then at that point prove that he caused the death, but with one of these mitigating circumstances were present, justifying the manslaughter conviction. So it's all, I think, focused on the use of deadly force that caused the death when the instructions are read as a whole. Again, I'm not aware of any authority for separating.
There's no doubt the force caused the death under the facts of the case. The question is whether the jury could have concluded, whether there's a substantial risk, the jury could have concluded that this was excessive force and therefore it must be manslaughter based on the instructions. That's really that's the case he's presenting, right?
Right. And sorry, can you repeat your question, Your Honor?
I mean, I think the question is, on these instructions, is there a substantial risk that the jury could have concluded that it has to be manslaughter because he stabbed him 137 times? Because they were never told that the excessive force has to be in causing the death.
I think I think the common sense takeaway from the instructions is that the excessive force caused the death, so there would be no substantial risk. Again, he doesn't explicitly say so, as the language in Carlino, for instance, would have it, but again, this is the model instruction approved and adopted by the Supreme Judicial Court, and again, the causation aspect is
it's not law,
part of
though,
it.
is it? It's the model instruction is not law. We're not bound by it. And it's not consistent with what Carlino says.
Sure, but I think there is a distinction with the model instructions on homicide as opposed to certain other model instructions.
Can we back up for a second? Because this case was tried as a first-degree case, right? And so it was tried on extreme atrocity and cruelty as being the basis for first degree?
And deliberate premeditation on both.
And deliberate premed. And so on extreme atrocity and cruelty, does the case law say that post-death events are relevant?
I'm sorry, that last part?
Does the case law, I'm sorry, I know these guys will help me later, but maybe you can help me now. Does the case law say that events post-death, that what the defendant does post-death that might be extreme, atrocious, or cruel, is relevant to first degree?
No.
No.
Short answer.
So the leaving the body with, under a tarp, with the, and bleaching it and things like that the prosecutor talked about in closing, not relevant to extreme atrocity and cruelty.
No, but it can be relevant to things like state of mind and malice, consciousness of guilt.
Consciousness of guilt.
Yes. But I think the case law on...
The fact that there were maggots next to the body, was that relevant to consciousness of guilt? Or was that just like the charred meat that the prosecutor was reversed for 20 or 40 years ago now?
I think to the extent that it may be gilding the lily perhaps on the prosecutor's part, I do think there's case law that the decomposition of a body can perhaps be relevant. There was evidence that the body was dumped in a trash pile, that everyone in this encampment knew that this was a trash pile. So it speaks to the defendant's state of mind, I would suggest, in placing the body there and concealing it there. But again, as to EAC, it's the manner of causing death that's relevant.
I share Justice Englander's concern about the description of how the body was left in the prosecutor's closing argument, especially because after talking about how the body was left, the prosecutor says, the disposal's body was inhumane, was inappropriate, it was unnecessary, it was not justified or proportional. Are they the acts of a person who acted in proper self-defense? Ask your common sense. And I'm not seeing how it could possibly go to self-defense, what you do to the body afterwards. Am I missing something? Or is that just a
I would suggest
error?
that piece of it is more to the state of mind, that this is not someone who's reacting as he had to kill in self-defense. This is someone, again, in a first-degree murder case who chose to kill the victim, and then as part of covering up his crime, this is what he decided to do with the body. And obviously
It's an interesting problem.
Yes.
It really is. I mean, I think there's a legitimate argument there somewhere for the prosecution to say, look, he says he took the stand and argued this was in self-defense. Are these the actions of someone who acted in self-defense, which include those things that occurred post-death? I get it. He gilded the lily. He gilded the lily a lot.
Sure, but even accepting that, again, I think the jury is able to sort out, hyperbolic claims by either side.
The jury was never told. See, I think these things are actually connected. He uses the word, it's not proportional. Are we now talking about the force and whether the force was excessive, which is the question on the fourth item of self-defense? Because if we are, the jury is never told the excessive force has to cause the death. You follow what I'm saying?
Yes, but not, I do think the instructions told them that the excessive.
You agree that that's the law? The law is that the excessive force has to cause the death.
Death results from the excessive force. That
Okay.
seems to be clear in the cases. But again, I think the instructions act,
Is there any case that says the other, says the opposite?
not that I'm aware of.
That excessive force post-death could be a basis for taking away a self-defense?
No, not that I'm aware of.
I'm
Not-
struck by the notion of, a guy comes at someone with a gun, all right? And the other guy draws the gun because the only way to defend himself is to shoot him, and he kills him. And then he fires 12 more bullets into the guy's body, and he loses his defense? That can't be right.
Again, a very different situation than what we have here. I'm not sure what a specific instruction would have to look like to address that. But again, I point to Darden. Again, I know it's an out-of-state case, but there's simply just no evidence that any of the wounds here were inflicted post-mortem. And in fact, over a dozen, between a dozen and I think about 24 of them, specifically testified contributed to the victims.
She testified that about a dozen contributed?
Yes, in the section of my argument where I list each of the organs and how many I believe the prosecutor goes through, and that wound contributed to his death, yes. In your opinion, that wound contributed to his death.
Thank you.
Yes.
Last question from me. Was the jury instructed on consciousness of guilt?
My recollection is they were, yes, but. All right, if there are no further questions,
Seeing none, thank you both very much. Excellent arguments. The case is submitted. Calling our next case, docket 24P1022, Commonwealth v. Jones. That wasn't 20 seconds. 16. Attorney Weber.
Morning, Your Honors. Philip Weber representing Mr. DERON Jones. Mr. Jones's case is here today as the search warrant, motion to suppress, should have been granted. One large issue in regards to it was that there was insufficient nexus to connect the materials in the application for the search warrant to Mr. Jones' actual apartment itself. That is, in regards to the motion to suppress, the relevant part, his actual apartment himself. There were other areas searched, but that's where all relevant evidence was discovered. Now, in the situation, the apartment was part of a larger complex, 3 buildings with a total of 150 apartment units in total. Now, the court has ruled that when you're dealing with that large of a number of apartment units, it changes the calculus. In fact, one case that, well, I do have various cases I cite in the brief. There's one that I did not, but Commonwealth v. Costa, 97 Massachusetts Appellate Courts 902, which held that a controlled by inside a large multi-unit building. In that situation, there was 144 apartments, so quite similar numbers, that the police observation of an informant entering and leaving the premises.
Is that Commonwealth against Costa? That's Commonwealth against Ponte, isn't it?
I have it written as Jeremy Costa, or Costa. My pronunciation may be wrong. That's why I refer to the specific.
Maybe I've got the wrong case.
No, but Ponte speaks to something similar.
But
go ahead.
But in that one, the problematic issue was that the police had observations of a confidential informant entering, leaving the premises, but not the specific unit itself.
But the question in those, I'm not familiar with Costa, I'm afraid. I read Ponte yesterday. The question in that case was whether or not the CI had sufficient veracity as to the apartment that the defendant was located in. Here, you have the police officer saying, we know he lives at, and we've arrested him previously. Isn't that enough to identify his apartment?
Perhaps to identify where he lives, but the question here isn't where does he live? Because it's not just enough to say he lives in a certain unit, he lives in a certain apartment, therefore we're going to search the apartment. There has to be more than just he lives there. It has to be enough to show that there's information to believe that the suspected drugs would be actually found in the apartment itself.
Leaves from that complex on multiple occasions before a controlled buy and returns to that complex after the controlled buy on multiple occasions, right?
From the general complex itself, there's never an observation of him leaving from the
but
specific unit.
Isn't that enough? You know he lives in the complex and where he lives, and you know that he leaves the complex and he comes back. That's not enough?
I would argue that it's not, Your Honor, because
What more do we need to know? What more did they need to know?
I think they would, if that's the basis, then basically we would have any situation where you could search someone's home regardless. There would need to be...
No, I'm going to search their home when I know that before they do a controlled buy, they leave from the area where he lives, and they return to the area from where he lives.
One issue
That's not every case. That's those cases. I got somebody who watched him leave and come back multiple times, 2 or 3 at least, right?
I believe at least in that range. There were a number of controlled buys. One of the issues in regards to it is the substance we're dealing with here is prescription pills. Obviously a very small item. It's something that could easily have been in his truck that they observe him in. There needs to be something to indicate that the drug was in the house. Now, if this was some large, bulky item that couldn't reasonably be stored in his car, well, then we would be dealing with a different situation. But it's prescription pills. It's quite easy for prescription pills to be stored in the car, or in a number of other locations. It's a large complex, so there's quite...
Can I just stop you? Are you making the argument vis-a-vis the Aguilar-Spinelli test here, or the nexus? Because they're different arguments.
Well, both, essentially, because I find there to be issues in regards to the nexus. I also find there to be issues in regards to the confidential informant. I think there are issues in all regards, in regards to search. So we're dealing with kind of both elements in regards to that.
The reason I ask is because Ponte is an Aguilar-Spinelli case. It's insufficient evidence of veracity because the informant didn't see the defendant going in and out of his apartment, just out of the complex, and there were 120 units or something like that. But that wasn't a nexus case. So are you arguing that Ponte should also apply to the nexus analysis?
Well, in regards to Ponte, it's more that I think it's illustrative of the issue with the nexus here. It's not that it's, because I think as stated, there is very much a nexus issue. I think it's more so that it is illustrative of the issue in regards to it. So perhaps that would lead to expansion, but it is ultimately that we don't have a sufficient nexus here to connect it to the specific.
Under Ponte or under some other authority?
I think a Ponte would apply as well in regards to this.
Well, I don't really get this. Unlike in Costa or Ponte, CS2 bought drugs in the apartment. Why isn't that enough nexus?
Well, in regards to that, I think one of the problems there is, and again, this goes to the fact that it's not one thing or the other, that this application for a search warrant, I think, is rife with issues. When it comes to that part of things, I think there is a question in regards to the base of information, because you have
this information, they bought drugs in the apartment. Isn't that a good enough basis of information that you literally yourself bought drugs in the apartment?
I would argue that in this case it's not, because the problem with that is that you have this incredibly generic statement from a confidential informant, and I will say a confidential informant, which, by the way, has not worked with the police in the past.
No, that's not true. CS2 had given information that led to the seizure of drugs.
I don't believe that was the same one that, and I apologize if I have my memory mistaken, there were 5 different confidential informants.
CS2 has provided information in the past that has led to narcotics-related arrests as well as the seizure of illegal drugs. That's on page 48 of the appendix.
Then I apologize, because the problem that one of the problems I found is that there were 5 confidential informants. 4 of the 5 had not been worked with the past, 1 had, and the information varies between the confidential informants. So my apologies to Your Honor that if I made a mistake in that regard. But one of the problems that I found is that the information provided, even from this confidential informant, is this generic idea of I've bought drugs from him in his apartment. There's no description of what the inside of the apartment looks like. There's nothing that can corroborate any information. There's just this kind of generic statement of, I bought drugs from him in his apartment, and the controlled buys, if anything, would indicate that he doesn't sell from his apartment. Every single controlled buy that took place, and there were numerous controlled buys, involved a meetup outside of the apartment. So you have a confidential informant saying, I bought drugs in his apartment, but every single controlled buy we see indicates that he wouldn't sell drugs from in his apartment.
Is there a case that says that someone has to describe an apartment in order for it to be a valid tip? That wasn't the case in Guardado.
Well, it's essentially the level of the base information, because the information provided through the confidential informants here is, I would argue, it is these broad, generic statements that have no level of specificity, to the point where it makes it almost impossible to challenge, because this idea of, well, I bought drugs from him in his apartment. That's the level of the base information. That is a statement that any person at any point can give. There's no, how can a defendant possibly challenge?
Well, you're not supposed to challenge it. We're supposed to see whether the four corners give probable cause. It's not a trial. It's to determine whether to issue a search warrant. And the magistrate is supposed to believe the officer's affidavit, right?
Essentially, the idea is supposed to be that, but there was at one point there was even a challenge, a request for a Frank's hearing, because in this situation, for instance, the confidential informant that the police have worked with in the past, the statement there is
CS2, right? We're talking about CS2.
Yes, I do believe that is the one that
He states that Jones conducts his drug deals from his apartment, at customers' residences, and from his Silverado pickup, which, by the way, they were able to confirm. He has a Silverado pickup, which was a new. So why isn't that enough?
Perhaps enough for the
Veracity.
vehicle.
He has veracity.
I would argue that there is an issue. I would disagree, Your Honor, and argue that there's an issue with the veracity. When it comes to the pickup, that is actually the one area where the information might be specific enough. But again, if the issues that...
What's the difference between saying he deals drugs from his Silverado pickup with a license plate number and he deals drugs from his apartment? What's the difference? He didn't say his apartment at 836 Willard Street?
He doesn't provide any real specific information. It's just this idea of he deals drugs. And again, the controlled buys show different than what he says. And even in regards to the information that's provided, everything are these incredibly broad, generic statements that leave the area where basically it's just, if the police, it's almost essentially this area of the police, if the police say, trust us, this is good information, and that's it, and the defendant's just supposed to sit back and say, well, I guess that's that.
That would be an inadequate search warrant, but I think, this search warrant details 5 controlled buys from your client. That means 5 people who went to your client and bought drugs from him. That's not a generic statement, I think X is selling drugs.
Well, and that's where we get into the nexus issue, Your Honor, because I do believe that they set up the controlled buys in order to try to address the issue in regards to the lack of veracity-based information.
And that gets us back to the question of, if you know where he lives and you know he left from the area where he lives and came back to the area where he lives, isn't that enough for probable cause?
And again, I would argue that it's not, especially considering the type of drug we're dealing with. There's nothing that, because there certainly is cases, I believe.
Why should we engage in the assumption that he's selling it out of his truck? Why, probable cause is not more likely than not, right? We understand that.
No, certainly, Your Honor.
It's also not hyper-technical. I'm struggling. It seems to me that your argument is that there had to be somebody standing in the hallway while he left, apartment 105, and if there wasn't, they can't search his house.
Well,
is that your argument?
No, Your Honor, it's not that it wouldn't need to be as specific as that, but I think there needs to be at least more to provide that nexus to his apartment, because in this application search warrant, amongst other issues, there's no indication even of the timing. We don't even know, once the call is made and the drug buy is set up, it doesn't say that he immediately gets into his car and goes. It's just this idea of, well, the drug buy is set up, and then at a certain point, the police observe him exiting a general area. And in fact, in one of the controlled buys, the area that he's observed exiting isn't even the building that has his apartment unit. It's 826 Willard Street, which is part of the three-building complex, but it's a different one of the three buildings. So for one of the three buys, they don't even have him exiting from.
Yeah, I noticed the Commonwealth didn't address that point.
I'm sorry to knock your train of thought, but I might be wrong here. Is CS2, are there two guys who are two?
They seem to use CI2 and CS2, so the numbering can be a little, because there were 5 confidential informants in total, and there's 2 of them have the number 2 in the title, but there's CI2 and CS2.
Oh, see, I was assuming the 2s were the same guy, but you're saying the 2s are different guys? There's a CS2 and a CI2?
From the way I read the application for a search warrant, I read those as 2 different people. If I'd been reading the search warrant, perhaps maybe a different numbering system would have been less confusing, but at least the way I read it, I do read those as being 2 different people. And there being, in total, 5 confidential informants.
Oh, so maybe the guy who did the purchase was not the guy who had to provide him information in the past, if they're different guys.
It does get the numbering system does become a bit confusing in that regard, but I do find it problematic because they set up I feel like there's this effort to inundate with large numbers, but when you actually look at the numbers, you have 4 confidential informants who have never worked with the police in the past in any way whatsoever. So it's kind of hard to state that they would have any level of veracity. You have 1 confidential informant who they say, oh, it's a registered informant, and there's that broad statement of, we've worked with this informant in the past and it's led to seizures, but we have no idea when in the past, how many times, what type of situations. I mean, we have no information beyond they've worked with in the past. So we have a point in which, for any type of search warrant, all the police really have to say is, well, we know this confidential informant's okay. I mean, the idea behind the veracity of a confidential informant is to test their veracity, but it's impossible for a defendant to actually test the veracity in any way, shape, or form, because what questions could possibly be asked in an evidentiary hearing? What way could it possibly be challenged? It's just, if the police say they're good, they're good. That's what we've kind of amounted to, because I understand that there's confidentiality. Obviously, there's a limit to what kind of information can be provided, but I think the defendant's right to be free from unreasonable search and seizures is also important and also has to be weighed within that, to the point where protecting a confidential informant's identity is important. The right to be free from unreasonable search and seizures is more important. Seeing as my time, unless there are
Time is up.
questions.
Let me see if the panel has any further questions. Justice Ditkoff, no. Justice Englander? No. Thank you very much. We'll now hear from the Commonwealth. Attorney Hunt.
Good morning, Your Honors. Attorney Brendan Hunt for the Commonwealth. Precedent has informed us that an affidavit should be read as a whole, in a common sense and realistic fashion, not parsed, severed, or subject to hypercritical analysis. And I suggest that that's what my brother on the other side is doing here, is subjecting the document to the hypercritical analysis. Speaking to the nexus.
Well, he says, look, there's probable cause my guy was dealing drugs, but that didn't give you probable cause to search his house. That's his argument, right?
Right, but here we have 2 confidential sources providing information. We have 3 confidential informants.
Why?
Did you say 3 or?
Sorry, 2 confidential informants and 3 confidential sources, 2 confidential informants.
What's the
Do you,
difference?
do you agree with your friend that CI and CS are different people?
Yes.
Ah, I totally missed that when I was prepping this.
Why do they do that?
So here in this case, in the investigation, the confidential sources approached the police. They informed them that the defendant was selling prescription drugs out of his apartment, out of his Chevy truck. All of those confidential sources were corroborated by the confidential informants who were the ones to actually go through the controlled buys.
So is that the distinction? Justice Englander just asked this question. Is the difference CS is just a source, but a CI is a source who actually does the controlled buy?
Correct. In this investigation, that's how I interpret it.
The only one with veracity is not the CS2, but CI2. Is that right?
I would suggest that each one of these.
Oh, I'm sorry. impose my own view. The only one who had a track record
Yes.
was the confidential informant 2, CI2.
That's correct. He was a registered informant with the PD.
CI2 doesn't say, I did any transactions with the defendant at his home, and he doesn't say he ever went to the defendant's home.
Not in this affidavit, that's correct.
Okay. So the home stuff comes from CS2. You can see how this could be confusing. Who is the confidential source, right?
Correct, yeah, the confidential
And
sources.
he does not have a track record with the police.
The confidential sources are each known to the department, and they've provided information in the past. The identity, the address is known.
Doesn't say that, I don't think. I just looked at it.
Let's see, so in...
It says that he's known to them, but I don't think it says that he provided reliable information in the past. It says CS2's true identity and address are known, and that's it.
And that's the extent, you're correct. And then he goes on to state that he's personally purchased prescription drugs from the defendant within the last 7 to 10 days from...
He's got the guys, and he's got the defendant's phone number, which checks out, right? And the Silverado pickup, which is also corroborative in the sense that it's different from the Camry, which he had been driving, right?
Correct.
Okay. So you would argue that's corroborative information that demonstrates his veracity.
Correct. And speaking to the nexus, I wanted to draw the court's attention to the SJC's argument, or decision in Hernandez from 2015 that a direct observation of drug activity inside the home or residence is not required. The nexus may be inferred from the nature of crime. And I would suggest to the court that here, with the six purchases, controlled purchases of direct observation of the defendant leaving the apartment complex, going to the
I think
site.
you anticipated my next question, which is you state at page 26 of your brief, quote, police surveillance confirmed that on 6 occasions, and then they give the 6 dates between 2016 and 2017, continue the quote, the defendant consistently left his apartment, traveled directly to conduct controlled buys, and returned directly back to his apartment on 4 of those occasions. I'm not sure that statement is correct. I thought the information that was received or observed by police officers was that they observed the defendant leaving the complex or returning to the complex, which is 3 buildings, 150 units each, in his truck. But I didn't think there were any observations of him leaving from his specific apartment or returning to it. Is my understanding correct?
Your understanding is correct.
Okay, because you say in your brief that he returned directly back to his apartment on 4 of those occasions. That's technically not true. He returned back to the apartment complex. We don't know if he entered it.
And my omission...
what Attorney Weber says is that's a critical distinction under Ponte. Could you address that?
I can, yeah. Direct observation of the defendant leaving, his specific apartment isn't required. What we have here is we have 2 confidential sources that provide the police with his unit, his specific address, and then we have 6 controlled buys where the police officers are able to, we have at least 5 controlled buys, where police officers are able to view him leaving the complex and traveling with observation throughout his travels directly to the prearranged site and then traveling back as the sole occupant of that vehicle.
How do you distinguish Ponte? I
Ponte,
think Ponte, the CI actually says, I went into apartment 6F, and that wasn't enough.
so in Ponte...
I would say Ponte is wrong, but that would be, I think, not the argument you should make.
No, not at all. In Ponte, it does state that the adequacy of police supervision that the buy lessens with the number of apartments in a multi-unit building, it increases. However, here, I think what we have are the facts sufficient enough to warrant probable cause, where we have 2 confidential sources corroborated by all of the controlled buys of the defendant leaving the apartment complex, going to his specific parking spot with his Silverado, traveling directly to the prearranged location, and then returning back, being the sole occupant, observed continuously to the same parking spot, and then walking and returning into the complex. I think that would establish, or at least justify reasonably, that there's probable cause that the confidential sources giving his unit 105 is
Well,
enough.
I think the answer to Justice, I know how much Justice Englander loves when I answer his questions posed to counsel, but I think the answer to Justice Englander's question is that Ponte is
I
a
am
case
so
that
happy
applies-
to have you answer this question.
I think it's that it applies to the veracity prong of the Aguilar-Spinelli test. It is not a nexus case. And I guess that begs the question. Attorney Weber says it should apply in the nexus context. So I guess that's my question. Has the Ponte rule, for lack of a better term, ever been applied to the nexus test? And I don't know the answer to that question.
Similarly, I don't believe that it
We're
has
equally at a loss. Okay.
What's that?
Nothing. I said we're equally at a loss. I'm wondering if Ponte should apply, if the logic of Ponte anyway should apply to the nexus test. That's my
Logic
question.
of Ponte?
No, I mean, Ponte is addressing the veracity, and here we've got more of a nexus issue. Well, if there are no further questions from the panel.
Nope. Very interesting case, well briefed. The case is submitted. Thank you, counsel. Much
you.
appreciated. Calling our third case on the list, docket 24P826, Commonwealth v. Simon. Attorney Spavento.
Good morning, and may it please the court. Today, we will be discussing whether or not there's enough evidence to survive a required finding of not guilty for strangulation. The parts that I want to focus on is, obviously, yes, there was intentional pressure. But was it substantial, and did the pressure interfere with normal breathing or circulation of blood? When you read the transcript, the victim stated, squeezed once and did not lose breath. And I understand for about 5 seconds. And I understand that the police officer stated it was 5 seconds for each squeeze. So there was a conflict of what actually happened. But also there was no red marks. Like, for example,
When did she say that she didn't lose breath?
it was, okay, let me rephrase that. It says, quote, "Are you able to breathe? Maybe. Yes."
Yeah, maybe, I don't know.
It's not exactly definitive. So I think it leaves to the jury what actually happened. Like I stated, there was no bruising, no swelling, no redness. And that goes to substantialness and the pressure interfering with the normal.
Jury was properly instructed, right?
Yes, Your Honor.
So why isn't that a question for the jury? That, they're told you need to find that it interfered with natural breathing or blood flow, right? That was the instruction?
Correct.
So why isn't it a question for the jury based on that? I think we can agree that it's at least, you might say more, but it's at least inconclusive.
Yes, that's a better word.
Why isn't that a question for the jury, given all of the facts?
That probably is a question for the jury. If it's a question of fact, I understand that.
All right. And I mean, you want to take it away from the jury. You want to say on these facts, given what she said, not enough.
Correct.
And, if it's not clear, but let me ask a different question. I mean, I think that is the nub of the problem, but there's another question out here. The police officer testifies on cross-examination, unobjected to, that it was multiple times and that there was pressure each of multiple times, right?
Yes, Your
Did that
Honor.
come in for the substance of what she testified to?
Do you mean, does that come in for its truth?
Well,
Is
she's
that-
the first complaint witness. Ordinarily, it wouldn't come in for its truth. However, the way it came in, there's no objection, there's no reference to it at all. And if it came in for its truth, okay, then doesn't that change the calculus? It's no longer one pressure on the neck, it's multiple pressures on the neck.
5 seconds each time.
Yeah.
No, I understand that. I'm not discounting the police officer's testimony.
You're not. So the
But-
police officer's testimony came in for the truth, even though it was first complaint witness and she's testifying to hearsay.
It should have been. I do agree it was not objected to. I came to the conclusion that was probably a strategy issue that the defense attorney wanted to leave it alone.
Well, the defense attorney brought it out.
Right,
It
right.
was on cross. It's very odd. I mean, obviously, it was a strategic decision. He was getting other things that he liked, but I don't know the answer to this question, whether that evidence came in for the substance. The judge did instruct on the limitations of first complaint to the jury,
No,
but I don't think the judge ever tied it back to that testimony.
I would agree it's a little confusion on how should the jury evaluate it for its truth or for something else.
Well, the question is a little different, counsel. My question is, when we're evaluating whether there was sufficient evidence to prove strangulation, can we consider the testimony given by the police officer as a first complaint witness? What do you think the answer to that is?
If it was for the first complaint witness, oh man, I was not anticipating that question.
Because it might matter.
I don't think it would matter. It
Why?
would- Because, well, you stumped me on this one. So I would say,
Well, no, I mean, it might matter in this sense. As you emphasize, the testimony of the victim was one time for 5 seconds, and maybe, I don't know, it cut off my breathing. The testimony of the police officer is multiple times for 5 seconds.
okay, so I think what you can look at is there was no, what did she mean by 5 seconds? I understand 1, 2, 3, 4, 5. But she did not lose breath. There was no redness. I mean, that's probably just an assault and battery. I would agree with that. That's an assault and battery. But there was no evidence, loss of circulation of blood. For example, some cases talk about like red marks. I think one of the cases the Commonwealth cited talks about that, but it's mere scratches. I think it goes to what is the evidence of actual circulation of blood loss or normal breathing. For example, some of the cases stated a cough that could be interpreted as interfering with normal breathing. I believe she testified so that by able to breathe, maybe yes, I don't know. And I believe the officer testified. Did she state that she ever lose breath? No.
The defendant was also charged with more than just strangulation, correct?
Correct, Your Honor.
And he was found not guilty of certain counts, correct?
Correct, Your Honor.
So is it possible that defense counsel's strategy on cross-examination was to address some of those additional charges, additional felonies? And that's part of the reason why he elicited that information on cross-examination and took that tactic?
I would agree that's possible. This is my shortest argument ever. If there are any questions?
We acknowledge this is a one-issue case, so let me see if there's any further questions. Justice Ditkoff, Justice Englander?
I don't have anything further.
No. Thank you, counsel.
Thank you, Your Honor.
Well briefed. We appreciate the argument. We'll now hear from the Commonwealth.
Good morning. May it please the court. Stacey Gothier for the Commonwealth. It's our position that the prosecutor presented sufficient evidence of strangulation. And where this is a sufficiency issue, we look at the evidence in the light most favorable to the Commonwealth and decide whether any rational trier of fact could have found the essential elements beyond a reasonable doubt. So here we're talking about the elements of the substantial pressure and the obstruction, the interference of the normal breathing or blood flow of the victim. She testified that the defendant had got on top of her and he, quote, he choked her. She described it as he put both his hands on her throat and he squeezed her neck. She testified that she told Officer Wong that she could feel the pressure for about 5 seconds every time he touched her.
Okay, so let's stop there and talk about Officer Wong. Did that come in for substance or not?
So if the judge did give a first complaint instruction prior to Officer Wong's testimony,
We did. So before she even took the stand, he said, this is a first complaint witness that's not coming in for the substance of what she says?
I didn't write down specifically the instruction that was given, but I did write in my notes that judge gave first complaint instruction here.
The next witness who is going to testify will testify to the complainant's first complaint. You may consider this evidence only for specific limited purposes, and then list the purposes. Why wouldn't that apply when they're crossing on how the victim described the assault to the officer?
Well, I mean, certainly it's presumed that the jury follows the judge's instructions. However, if it doesn't...
That doesn't matter. That doesn't even matter.
So
This is purely a question of law.
If you
Was
don't-
the evidence sufficient? And you argued in your brief that this evidence was relevant to our determination, and hence I went and sort of started asking questions about whether or not it came in for its substance.
So if something is admitted without objection, then it would come in substantively for whatever purpose the jury sees fit.
Sure. But if the judge gave the instruction that she's a first complaint witness, is not coming in for the substance before she takes the stand, I don't think counsel has to stand up and object again each time for each question? Does she? Does counsel have to do that? They don't, right? I mean, I would tell you what I think the answer is. You can disabuse me.
You're supposed to let the judge know what your objections are so that the judge can address them, right?
But if the judge has already told the jury the first complaint is only for corroboration, and then you have discussion of the first complaint, why do you need to object? The jury's already been told it's limited.
So, if that's the case and then the jury can't consider that as part of the substantive evidence, I think that there's still...
Okay, so let's get to that part of your argument then. Let's forget about what Detective Wong said, because it appears, I'll go check the record, that the jury were told what you're about to hear is not substantive evidence. Now, or it doesn't come in for the substance or for its truth. Now, so that leaves you with, once for 5 seconds, was your breathing impaired? Maybe, I don't know.
So,
or could you still breathe? Yes, maybe, I don't know.
I don't know.
Right?
So that's equivocal. However, one of the words she used...
That's a good word. That's the word I was looking for.
Yes.
I could have given you
One of the words she used to describe what he did to her was he choked her. And if looking at Commonwealth versus Cosenza, which is in my brief, and it's an unpublished case, so I recognize that this court is not required to follow it, but the court in that case looked up choke, and in the dictionary they found that the definition was to check or block the normal breathing by compressing or obstructing the trachea.
Then we have another case, also unpublished, where the only testimony was, it was a statement, I think, because there was no testimony, but it was a statement that came in, he choked me, and the holding in that case, granted, unpublished, was just using the word choked is not enough.
That's correct.
Is that right?
Well, the facts in that case they're both different. So the Davis case that you're talking about where it was not enough, the only evidence in that case, it was a 911 tape that came in, and the only thing was a conclusory statement that he quote, choked her. Here in this case, we have a live victim who testifies that he choked her, right, which she then describes, right? It's not just a conclusory statement choke. She describes he got on top of her, he put both hands on her throat, he squeezed with his hands. She said it lasted for about, 5 seconds. So I would suggest that that's more evidence than what was present in the Davis case.
And that she felt fear.
Yes, and that she felt fear.
So we're addressing the third element of strangulation, right? That the pressure interfered with the normal breathing of the victim.
Yes.
What is your best published authority, your best precedential authority for the proposition that the evidence to which you just referred is sufficient to meet the third element of strangulation?
So, I think you can look at Commonwealth versus Rogers, which I do also, there was more evidence in the Rogers case than in our case. However, one of the things that in Rogers the victim testified was that when the defendant was applying pressure to her neck, she testified that she felt scared when he put his hands around her neck. And here, she testified that she felt fear. So we don't have as much as Rogers, but in Rogers, that's a published case.
And that's your best case?
Published, yes. And then I just would just add quickly, although she was equivocal about whether she could breathe during the incident, again, looking at Cosenza, which is unpublished, in that case, there was a police officer who testified that he saw the defendant choking the victim, and he could hear her like yelp or yell out while he was doing it. But the court in that case found that to the extent that she was able to yell or scream while he was, choking her, that only went to the weight of the evidence and not the sufficiency, because the statute doesn't require complete strangulation. It only requires interference with breathing or blood flow. And if there's no further questions, I'll rest on my brief.
Seeing none, the case is submitted. Thank you both. Well briefed.
Thank you.
Sure. We're flying. Rock and roll.
Calling our fourth case on the list, docket 24P 968, Lucey v. Kinnon.
Good morning, Your Honors. Scott Lucey, appellant and cross appellee. Your Honors, we have two cross appeals here. We'll argue them both within the 15 minutes. Is that the court's pleasure?
Please, thank you.
Better get moving then. That's a lot to cover. Thank you. Your Honors, a 12B6 motion is to be allowed if and only if there are no circumstances under which a pleader can prove their case and have any relief from that. And I think the lower court's holding here found a ruling that included in its written decision an acceptance of a number of multiple theories put forth by the other party. Those are factual assertions and explanations of the defamatory statement that go far beyond whether the complaint was sufficient enough to make out a complaint. In my complaint, I was somewhat hamstrung that I could provide really no context because the person making the defamatory statement had blocked me on social media, so I could not provide any background, any context, any prior communications, all of which would have stood in contrast with this statement.
Well, how are they? I think that, don't we have the context surrounding the statement, someone must have taken the bar exam for you? That's what you claim was libelous, right?
Yes, Your Honor.
And we have two posts that precede that, one by the defendant and then a response by you, right?
That's correct, Your Honor.
What other context will bear on whether or not this statement is libelous?
Certainly, Your Honor, there are decades of...
But why do they bear on whether this statement is libelous?
Because after making the statement and after my questioning about the meaning of it twice, or an explanation of it twice, the defendant chose to block me. Now, that's an unusual course of action to take for someone who had just gotten through saying, I never back down from a fight. So I would, had I been able to, present to the court 100 prior things, none of which are defamatory, but the defamatory statement stands in complete contrast with all those other statements because of the defendant's reaction to his own statement and upon being questioned about it.
The question of law for the court below and for us was whether or not the statement that you're claiming was libelous, right, could be reasonably understood as a statement of actual fact. Isn't that the question of law?
I think it is.
Okay. Why do we care about all the rest of that stuff? I mean...
I'm sorry, Your Honor, could you repeat that?
Why do we care about that other stuff? Because we have to consider the audience for this particular statement, not the audience for thousands of other statements of which we don't know who the audience was. But for this particular statement, as to this audience in this context, could that be reasonably understood as a statement of actual fact? That's the question for us.
Understood and completely agreed, Your Honor, that the rest of them don't matter, except they do provide contrast. There's a mountain of prior communications. So why on this one? It's a question that raises the crucial issue of fact for the whole case. The court's holding here goes beyond the basis of my complaint. Yes, it was very short. Yes, it is a short and plain statement. But the four elements of defamation are all applied here to the facts. The court makes a factual ruling, which a court should decide only if, whether it's fact or opinion, is unambiguously a fact or opinion. Now, if someone chooses not to explain their own statement in the moment, I think that leads to a reasonable basis that a complaint should not be dismissed on its face when there is an outstanding issue of fact that could prove the whole case.
Wait, are you saying that the complaint doesn't have to state the facts plausibly showing relief, just has to suggest the facts exist that aren't in the complaint?
Certainly not, Your Honor, of course. And I believe that my complaint does lay out the facts, that there was a statement about me offered maliciously or with reckless disregard for the truth or knowing it was untrue, and that it was published. I think the facts are clear. That goes back to literally all I could provide was a short and plain statement as required and really encouraged by the rules. It's not supposed to be frivolous. But I could have fleshed out a better case, but for the whole reason that I have a case, I couldn't because I can't get any of the other.
You had access to what you had asked him to do, right?
Yes, I did, Your Honor.
You didn't put that in the complaint.
I believe I did.
The actual request and his lack of a response, that was in the complaint?
The copy of the document?
Oh, because it wasn't in the text of the complaint, but if I go to the attachments, I'll find it?
I believe it's either in mine or my colleagues.
Okay.
And I don't think that's factually in dispute, Your Honor. I think in both of our briefs it may be in there that...
Wait, there was nothing attached to your complaint, right?
No, at the time, I could not. I ended up having to get someone else long afterwards trying to piece together.
That's what I thought. I don't remember any attachments to the complaint.
In addition...
That's correct, Your Honor, but that's the reason why I'm here.
You also need to plead damages, correct?
Or professional, or damage to a professional reputation.
Right. And what you state is that the statement could damage your reputation in the community. So we're bound by that statement. What legal authority supports the proposition that a statement that, in a vermin to the effect of this could damage my reputation in the community as well as standing within my profession, states a claim of damages for purposes of 12b-6?
I believe Ravenkar specifically uses the word could. that which may prejudice the plaintiff's profession or business, as this statement certainly does, are actionable without proof of economic loss. I'd also suggest, Your Honor, and I understand it's my own complaint, but using the word could rather than did, it represents an unknown, but I'm relying on the case law.
But doesn't damage have to be, again, alleged and proved?
Proved, sure, I'd love a chance to prove it.
Alleged and proved, but.
It has to be alleged, right? That you suffered actual harm? Isn't that an element of the claim?
To my professional reputation? I don't know how I'd be able to how do you prove? How does someone know clients they didn't get or legal work they have not gotten?
Well, I got to tell you, proof of loss of reputation has been around for hundreds of years. That's a claim. People have proved it. I don't know. I don't think I ever tried one of those cases, but it's not. You're not the first to have to worry about the problem. The question is whether it's an element of your claim. I think it is.
It is an element of the claim, and I understand the obligation to prove it.
To allege it in good faith. Based on this statement, someone must have taken the bar exam for you. You needed to allege that you suffered harm to your reputation, your professional reputation, as a result of that statement. And you had to allege it in good faith. That's part of the way this works.
And I think as pleaded, my complaint does match up with what the case law requires.
Okay.
So let me ask a question about the special motion to dismiss.
Please, Your Honor.
This was a forum, I think, entitled Facebook Malden Mass Politics or something to that effect, correct?
Something like that, Your Honor, yes.
So why is this statement made by the defendant here not petitioning activity?
Well, I don't know what sort of civic engagement you could be attempting by attacking an adversary's professional credentials. I don't believe there's any public activity or public action at issue here with making that statement. And I think the argument against me is that just because the defendant otherwise petitions or otherwise petitions in this group or otherwise petitions in and around there, that somehow every statement would somehow be protected. I can't imagine any public interest advanced or anything else that would come under the protection of 59H by attacking the professional credentials.
Let's say you're trying to get people to vote down a zoning change. And you say, you should vote down this voting change because they're trying to slip it by you. And then someone says publicly, they're not trying to slip it by you. You don't understand how scheduling works. And that person says, don't listen to him. He's a crooked lawyer. Wouldn't that be something that was trying to get people to vote down the zoning change?
It may be a dangerous statement to make, Your Honor, but to call someone a crooked lawyer is very different than saying someone must have cheated on the bar exam. A crooked lawyer is subjective, must have taken the bar exam for years.
He steals, don't listen to him, he steals from his clients. Why isn't that intended to get people to vote down the zoning changes?
Well, does the person in question actually steal from their clients? I think that's...
Let's assume he doesn't. I'm just trying to figure out this petitioning activity.
When my colleague first brought up to me that there would be a 59H motion against me, I wasn't familiar with anti-SLAPP. I had never run into it in my practice. And I went home and I read the cases that my colleague had recommended to me, which were different than...
You were as confused as we were.
Your Honor, yes. I figured I was either the dumbest person in the room. Thankfully, I live alone. I was the only person in the room, or I was being gaslighted. I don't think the answer is either of those, but I do think it's somewhere in the middle. I think by having a second motion, maybe it bolsters a first. I think maybe the lower court could have done better with the 12B6 if I wasn't also at the same time arguing against the 59H that I really couldn't get my head around. I could not reasonably imagine. I mean, if nothing else, the defendant here has put forth the 59H against me. The issue that was in question at the time of that statement was the timing of a city council meeting. That was in June of 2023. That meeting took place, I think it was that week, or maybe...
That doesn't matter. The timing of the meeting itself doesn't matter. What matters is whether or not your claim is based on his petitioning activity at the time. That's the question. He says, I was engaged in petitioning activity because I was trying to influence people to pay attention to a matter that was going to be voted on in the city of Malden. All right? And you have sued me for something I said in pursuit of that petitioning activity, or as part of that. It has to be as part of that petitioning activity. That's the claim. The fact that the thing didn't take place for another 6 months doesn't matter. What matters is what was going on at the time. He says, your lawsuit is based on my petitioning activity. And if it is, and he's right, you're going to have to pay his attorney's fees. So this is significant, okay? And I don't think it's an easy question under our case law, unfortunately, as to what actually was going on here. Because would you concede this much? The statement that preceded your response was a discussion of governmental issues.
It was a discussion of the
Statement by the defendant, where he mentions the fact that there's going to be I think it's the city council of the city of Malden is going to address a zoning issue. That's a statement on governmental issues, right?
Could you repeat it, Your Honor?
The statement that preceded your statement. So there are three statements at issue. He says something, you say something, and then he says someone must have taken the bar exam for you. Let's go back to the first one. The first is a statement about governmental issues, right?
The timing of government issues,
Yeah.
which, fair enough. If you think about law, you study contract law and civil procedure. One is substantive, one is procedural. They're both equally important. If Your Honor sees it that way, I understand the question.
Okay, so maybe that's petitioning activity, right? Maybe. If it were directed to the City Council of Malden, it would be petitioning activity without doubt. If he said, hey, I got a problem, I think you're trying to hide this meeting by burying it in a time when nobody's around. Petitioning activity. If he said it to the city, if he said it to the committee, right?
I agree that statement
Okay.
would be petitioning activity.
All right, so the question for us really is, does what comes after that somehow fall out of the definition of petitioning activity, right? I'm saying this in part for Mr. Cooper's benefit, because he's about to stand up and talk about this.
If I could finish briefly and make one last point, if I could answer Your Honor's question, just one final thing.
We'll give you time. Go ahead.
Thank you, Your Honor. If going back to Justice Ditkoff's question about what is and what isn't, there needs to be a reasonable relationship. I think a court would find that between a statement and some kind of petitioning activity. I don't think a court reasonably would find that all statements in advance of something.
Make that point in your brief, and I think it's a good one, that he doesn't get insulated from any kind of behavior simply because he started with something that could be described as petitioning activity.
It also fast forwards over the other prong, the other hurdle that a claiming pleader needs, which is to show that my complaint is based solely on the petitioning activity. And I understand Your Honor's point that the lawsuit was months later. However, if the point of 59H is to preclude someone from chilling petitioning activity, could not possibly chill someone when the petition activity had been completed and the other side had no knowledge of any lawsuit. I didn't even. I gave this months of careful thought and deliberation.
Understood. Let me see if there's any further questions.
Is there anything else I may address for the court?
Well argued. Thank you, Mr. Lucey,
Thank you, Your
Attorney
Honor.
Lucey. And we will now hear from Attorney Cooper. And Attorney Cooper, a good place to pick up would be where Attorney Lucey left off.
You got it, Your Honor.
And let me ask you, let me put it in this context. The statement at issue is anybody who would hire you to be their attorney, God bless them, because someone must have taken the bar exam for you. I understand in context how that is arguably petitioning activity. But how is it solely petitioning activity?
Your Honor, it is a classic part of petitioning activity to try to undermine the credibility of your opposition in a public forum. And that is exactly what was going on here. And I think, to respond to all of your questions about the 59H motion, and I recognize that we're now back to the Dura-Kraft standard after making efforts under Blanchard, and I know the SJC has another slap case coming up shortly that may further alter the landscape. But it is completely part of petitioning activity to literally insult your opponent in order to try to foster public participation, which is one of the definitions of petitioning activities.
Without limitation?
Without limitation. Let me explain, Your Honor.
Whoa. Let me stop you right there, and I'll give you a chance to explain, but I'd like you to answer this question. I want you to assume the exact same facts here, but instead, assume your client wrote the following. Anybody who would hire you to be their attorney, God bless them, because I happen to know for a fact, and this is true, that someone took the bar exam for you.
Your Honor.
Is that solely petitioning activity?
For purposes of the anti-SLAPP statute, it is. For purposes of getting to the second prong on whether there was a factual basis for it, grounded in fact, which if there wasn't, you don't get the protection of the SLAPP statute, and you are liable for defamation. So you're jumping, Your Honor, with all due respect, to the second prong that Mr. Lucey had the burden to demonstrate that something was devoid of fact. In this instance, that didn't apply because what he was talking about, including the full statement, was a statement of
How would you go
opinion.
about deciding that?
I'm sorry, Your Honor?
How would you go about deciding the second prong under those circumstances?
You don't, well, there are two aspects to the second prong. Whether a factual statement is in fact devoid of a reasonable factual basis or a reasonable basis in law. And that's now going back to Dura-Kraft, that is the burden of the non-moving party under 59A.
Because you can't construe the Anti-SLAPP Act to the point where it interferes with his First Amendment rights to file his lawsuit.
Well, as Dura-Kraft said, Your Honor, it's a conundrum because both are petitioning activity.
You have to resolve the conundrum, and your argument, I had the exact same hypothetical written down. Your argument, it seems to me, causes a real problem if we have to go to the second prong in order to resolve this. You're saying my client with impunity can accuse him on a factual basis of being a criminal or a liar or whatever, and I get to have his case dismissed unless he comes forward with all the basis for his claim right then and convinces a court that...
So, Your Honor, there are two steps in this process. The first is whether the complaint is based solely on petitioning activity. And as I argued from the get-go here a few minutes ago, the part of petitioning activity is to undermine the confidence of the public who you are trying to inform about an issue about your opposition. And here, essentially, Mr. Kinnon was saying, he's stupid. Okay, now the hypothetical you gave me is far more extreme, that Justice Neyman gave me, but you were going to sign on to, is far more extreme. Let's say that the statement was made, he's a criminal. That doesn't change the fact that the statement was made here in an online public forum, the equivalent of a town green, in connection with petitioning activity. What the non-moving party then needs to do, and is charged with doing under the Dura-Kraft conception, is to come back and say, okay, that was petitioning activity because, among other things, and it's not just direct communications to the government, one of the definitions of petitioning activity under the statute is that you are encouraging people to public participation.
Yeah, but doesn't Blanchard put a gloss on that language?
Blanchard's gone, Your Honor.
No. The second prong of Blanchard is gone. But the part of Blanchard where it talks about what is and is not petitioning activity, nobody's overruled that.
Okay. Your Honor, just like in McDonald,
You agree with me about that? Because I read Blanchard yesterday for this reason, and I think that's still good law. And I think Blanchard has to be limiting the breadth of that language.
Your Honor, both the appeals court and the SJC have recognized in cases where the publisher called the plaintiff a Nazi or a sleazebag or running a sleazy operation, held clearly, that's McDonald versus Patton, it's One Office Inc. versus Lopez, uses all of those words. The words were said in the context of petitioning activity. But just like in both of those cases, when you get to the second prong here, and I don't think this is inconsistent at all with Blanchard, because the bituminous...
Blanchard suggests it has to be directed at the government.
Blanchard suggests that ultimately there has to be encouragement for someone to petition. And by the way...
Blanchard suggests it has to be directed at the government. It can be indirectly directed at the government, but it has to be directed at the government, doesn't it?
In that particular context, but Your Honor, there were city councilors on this forum. They are part of this forum. It's undisputed on the motions that the public officials...
No, it's not true. You got to stick to the facts. It says were or are now. We don't know the answer to that question, and that was your burden of proof.
In terms of...
Am I right? I read the record for exactly this issue. We do not know who was in that forum at the time the statement was made.
Of course.
Correct?
We don't know.
Okay, so we don't know.
But we know that Malden public officials are signatories. They're part of the 2,000-plus people who are listed as members of that Facebook page who have contributed to it. And respectfully, Your Honor, again, in 59H...
Whoa. I didn't see that. I'm asking factual questions.
Yes.
I didn't see that we know who the 2,000 people are who are part of that group now at the time that the statement was made. I saw have been or are now. That was the language that was used. And have been is kind of irrelevant because we don't know.
Well, that's because the city council changes over and people come and go. So the reality...
Not in the record. We don't know.
Okay. Your Honor, as part of 59H, before you even get to that issue about whether there was direct petitioning, Blanchard did not deal with the language in the statute that says communication publicly designed to enlist public participation is protected petitioning activity. It's
but what Blanchard said was the statements that were made internally to a wide swath of employees was not, right?
Because those employees didn't have anywhere to go.
How do we know? How do we know that?
The facts of the Blanchard case, it was Kearney Hospital.
On those facts, if we take the language that you're talking about, surely there were people there who might have wanted to influence the government, and yet it was held not to be petitioning activity.
That was in an employment context, challenging the Harshbarger report, which was an internal report at the hospital. In this situation, it is undisputed in the record that there was a meeting that was going to take place, and Mr. Kinnon, inartfully and maybe even as a juvenile, using juvenile language, was enlisting members of this public forum, again, the modern equivalent of a town green, to attend the meeting because there was a potential zoning change with regard to MBA communities and whether there was going to be affordable housing built. A critically important local issue. He was saying they're trying to, just as Justice Ditkoff suggested, they're trying to slip this meeting by you. You're not getting proper notice of it. Mr. Lucey responds to Mr. Kinnon and says, baloney.
How broad is this? Okay, the modern equivalent of the town green, the analogy to the McDonald case. What is it about this that distinguishes it from any time somebody gets on a chat room page on the internet or Facebook?
Because this is a dedicated page that one must affirmatively sign up for to discuss Malden Politics. The name of the page is actually Malden MA and Politics. And
So if I set up a page like that, now anything that's put on that page is petitioning activity under the Anti-SLAPP Act?
well, I think it's more fact-specific than that, Your Honor. If you set up a page and
What facts get you there?
the number of people that are involved, the subject matter that is taking place. So, for example, Your Honor, if Mr. Kinnon had used this page, divorced from the idea of a public issue under discussion, and had simply accused Mr. Kinnon of being a criminal, that would not be petitioning activity. That's the Global Naps case from the appeals court, where there were statements outside the realm of petitioning activity that were communicated to the media.
But here, it's inside the realm of petitioning activity because, as you say, I'm just insulting my opponent who's responding to me.
Correct.
And that's petitioning.
So you're saying it's not just petitioning, it's solely petitioning. And
Solely
what you are saying is that as long as the context of the discussion involves a political issue or political subject matter or public discourse or whatever it may be, anything said in that context, regardless of how mean, irrelevant, or possibly defamatory it is, it passes the solely petitioning activity test, and then you say we go to the second prong to get to the
It does, Your Honor, because the first part of the test only examines really the actions that are taking place and where they're taking place.
I understand that, but I'm trying to understand the distinction between petitioning activity and solely petitioning activity.
Okay. So again, Your Honor, our argument here is that part of petitioning activity includes what Mr. Kinnon was responding to that was introduced by Mr.
Because of the greater
Lucey.
context of the conversation.
The conversation starts with
I know the
Mr.
fact.
Kinnon.
Yep, got it.
Okay. So, Your Honors, if I may.
Play that out. I mean,
Sure. The conversation starts with Mr. Kinnon saying, there's an important meeting coming up, and they're trying to slide it by you. I'm characterizing here. I'm not literally
Johnson
quoting.
says more or less, geez, this is odd coming from you who've done X in the past.
You're a former city council. You know this is about their summer break. It has nothing to do with the importance of this issue. Mr. Kinnon responds, basically directing Mr. Lucey to his prior email, and the full quote is, I'm beginning to wonder whether you know how to read.
So let me ask you this. What is your best authority regarding the discussion that we just had? That as long as the context is petitioning activity, it's solely petitioning activity, and then to address, in this context, a defamation claim, we have to go to prong two. Best case for that proposition.
McDonald versus Patton, Your Honor.
There's something that distinguishes McDonald.
Well, again, McDonald dealt with a virtual town square in the same way, and I believe that the comment that was made, and I may be confusing this with the Nage case, which was about someone being a communist, but I believe that the comment that was made in McDonald versus Patton was that someone
McDonald
was a
against
Nazi.
Patton is she's got a basically place where she will post things that other people put in about her town. And someone put in the definition of a Nazi.
Yeah.
And then changed the definition of a Nazi so that it appeared to be of and concerning the particular plaintiff, right?
Correct.
But the question in McDonald, the issue in McDonald was different. It wasn't whether she was engaged in petitioning activity.
I think that the focus of McDonald at the time, and given the age of the case, which was 2003,
Correct.
was the virtual town square aspect of it. But my point is, once you determine this is a virtual town square, talking about local politics, it makes what is being said about a public issue, no matter how inartfully, no matter how defamatory, petitioning activity.
Your time is up, but just as I gave Attorney Lucey, we'll give you another minute.
Your Honors, I would only emphasize that at the end of the day on both of these issues, And I have not spoken about why the trial court got it right in terms of the statement in context being hyperbolic protected opinion, but it applies equally to that. We are talking about core constitutional values here, both that underline the protected speech, the ability of a judge on a motion to dismiss to determine that in full context a statement is unambiguous. It has the cautionary words, I wonder, must have, that are speculative and cautionary, the hallmarks of an opinion. But also, there is a right to petition under the First Amendment. And while this area has for 30 years now been a conundrum for our courts, it is clear here that under Duracraft, after one considers the context and accepts that it's a town green, if the court accepts that, what Mr. Kinnon said about trying to get people to show up at this meeting about zoning is petitioning activity. He doesn't necessarily win. If Mr. Lucey had come forward and able to show, no, it's really defamatory, it's without factual basis in fact or law, but once the court determined it was opinion, that's a burden that could never be carried. It's protected speech. Thank you, Your Honors.
Justice Englander has another question.
I got some stuff. I mean, you got more than one First Amendment interest at stake here. And when you're talking about your client's First Amendment interests with respect to being sued for libel, there can be no debate. The First Amendment is implicated, and we've got a lot of law around it. And I have a question for you on that. But there's also a First Amendment, there's also a petitioning right to the plaintiff. And if you construe the Anti-SLAPP Act too broadly, and the SJC has said this, if you construe it too broadly, you start to interfere with that First Amendment right, perhaps in a way not intended by the legislature, right?
Yes.
And the petitioning is defined, I mean, the words of the First Amendment are to petition the government for redress of grievances. Your argument about this being petitioning activity is a long way from petitioning the government. That is a statement and a private website. Now, maybe the language of the statute can be construed as broadly as you say. Maybe it has been in McDonald, okay? But when it becomes, I now have a lawsuit against this person for bringing a lawsuit. I have a lawsuit, my Anti-SLAPP Act, because I'm going to get my attorney's fees. And I have a feeling, Mr. Cooper, that yours could be more than a few bucks. Then we have to think about the First Amendment rights on both sides. Let me ask you a question that goes to your primary First Amendment rights. Is the question what a reasonable person would have understood under the circumstances a question of law?
It is.
Whether they would have understood that it was a factual assertion.
In the first instance, it is, Your Honor, where the...
What says that? Because I read my decision in Kelleher, and I don't quite say that. All the cases seem to assume it is.
Myers versus Boston Magazine says that explicitly, Your Honor.
Okay.
That was the statement where Jimmy Myers was portrayed. The statement about him was that he was the only newscaster in Boston, it's back in the 80s, only newscaster in Boston who was in school for remedial speech therapy. And the court basically said, look, in context, where this was an evaluation of best and worst in Boston of a number of different professionals, it is unambiguously hyperbolic rhetoric. There is Supreme Court legion cases in terms of the court taking close looks at cases, defamation cases, because they implicate speech.
Well, both, but...
Yeah.
Okay, that's helpful. Thank you.
And Justice Ditkoff has a question.
I have a question about a side issue, not about the meat you've been talking about, appellate procedure. So I noticed that you didn't request attorney's fees in your principal brief, but you requested appellate attorney's fees, but you requested in your reply brief. And the way I read the rule, if you don't request in your principal brief, you lose your entitlement to it. And do you disagree with that?
I don't disagree with that, Your Honor, and I can only say I've done everything that I can to avoid having to even seek them in this case. So we'll stick with the trial court fees if the court decides to award them, on some level, the statute becomes punitive in my view. And I agree with Justice Englander that there are First Amendment concerns all around here. I would add only one thing, though, that the volitional act that starts all of this is the plaintiff's decision to file the lawsuit. And that's how we got here. Thanks.
Thank you, Attorney Lucey, Attorney Cooper. Excellent arguments, much appreciated, and the case is submitted. We're going to take a 10-minute recess. Good morning. Calling our next case on the list. Docket 24P1372, Sullivan versus People's Bank. You'll hear first from, is it Attorney Lewis?
Plum.
Attorney, my apologies, Attorney Plum for Mr. Sullivan. I went with the opoly first, my bad.
No problem.
Good to see you, counsel. Thank you.
Thank you, Justice Neyman. May it please the court, my name is Jerry Plum and I represent the appellant in this matter. The case presents what I think is an interesting question regarding the payment of variable compensation to an employee who voluntarily terminated his employment, having fulfilled, in our view, all the preconditions to receiving his variable compensation payment after the year that he left. Mr. Sullivan gave notice in January of 2021, and the payment in question was due for the year 2020. The variable compensation program at the bank consisted of what we argue were arithmetically determined amounts due to the employees based upon the performance individually against set goals at the beginning of the year, the performance of their department against set goals, and the performance of the bank overall against set goals. These weren't profit goals. These were goals such as an increase in depository fee income year over year, an increase on the individual in commercial loan income, that kind of thing.
Can I ask a preliminary question?
Certainly.
I know there's no 93A claim here, and I assume that was because it's an employer-employee context.
Correct.
Was there thought to equitable claims, which obviously, if it's a breach of contract, you're not entitled to, but why not a promissory estoppel?
I did bring a breach of contract and
Breach of good faith and fair dealing.
breach of good faith and fair dealing. Yes, which in the context of the breach of good faith and fair dealing, my view is that I did raise promissory estoppel type arguments, that this was really a pretext, this late rise to the discretionary nature of these payments by the bank.
But that would require a promise.
Well,
Both
yes,
a contract and a breach of covenant of good faith and fair dealing would require a promise. Where's the promise?
Well, the promise is that for 17 straight years, Mr. Sullivan worked at the bank and along with all the other employees received his variable compensation payment.
So it's an implied contract from the behavior of the bank for 17 years?
That and in his initial offer letter, which is in the record, it says your compensation will be your base pay, your opportunity to earn variable
Opportunity?
It actually said
Potential.
potential. And that-
Potential.
so
That's a promise?
Justice Englander stole my question, which
Yes.
is what contract was breached and what specific provision of the contract was
Well,
breached?
it's the terms of his employment that he was told that, on the way in and as he worked, that he would be getting these variable compensation payments, that all employees actually got them.
Understood. We
Yep.
know the facts. But if you're going to allege and prove a breach of contract, don't you have to specify the contract in the term that was breached?
I believe we did in count two, said that these were the terms of his employment, his at-will employment, that he was promised these payments, that he received these payments for 17 years, and that he was...
So the implied contract was formed when? In the offer?
I believe it was formed in the offer and
That says potential, so
over
how do you
time.
and again, it's an interesting issue. I'm not asking an academic question. How do you get around the fact that the offer said you have the potential to get this?
He did, and because of the way the program is structured, it's an all or nothing proposition. Once the bank determines bank-wide to issue variable compensation payments, everybody who's eligible gets them. And as explained to him, for the eligibility, you had to work the year, right? You had to have the metrics work out so that they generated positive numbers, and then you got your payment. It wasn't a gratuitous bonus of, at the end of the year, we like the cut of your jib, we're going to give you an extra 10 grand. It was a calculated program that was in place that was
But there's no allegation that I saw that he was promised this payment, or that there was a description of this program in detail that said you're entitled to this, right? There's no allegation to that effect.
Well, interestingly enough, there is a plan document, but it was undisclosed to him throughout his employment. He wasn't even told of the existence of that document, and the bank now, in the underlying case, produced the document in discovery and said.
And the bank says at any time he could have asked for this, and that seems to be undisputed. I've seen no dispute on that.
How do you ask for a document you don't know exists?
Because you know that you're being paid that way, and therefore you would say, hey, do you guys have rules about how you're paying me? That happens.
And what the bank actually testified, I know they say that in the argument, but if you look at the deposition testimony, what they testified to a person, and particularly the head of human resources, was that the only way an employee could find out about what the terms of the program were and what the eligibility requirements were verbally from the person's supervisor. So
Whoa, wait. That's exactly what I was asking. They say over and over again, this document was available if you asked. And I didn't see that as a disputed fact.
The disputed fact is that.
Do you dispute that if you had asked, they would have allowed your client to see the document?
Yes.
On what basis?
On the basis that the head of human resources said that it was kept not in electronic form, it wasn't generally made available, it was kept only in hard form in human resources. Mr. Sullivan's supervisor said he didn't even know about the existence of the document.
Did you ask during discovery, has anyone ever asked for this document before and been shown it?
I did, and the bank officers said that they had. The treasurer said, yes, I've seen the document. I asked to see it. And I asked him, I think, did you know it existed?
I mean, I got to say.
But just logically, Your Honor, how can you ask for a document?
We're not going to dispute it on the basis of logic. We're going to dispute it because it's disputed. They make the statement in their brief multiple times. And I didn't see any place in your briefs where you disagreed.
My point is that you can't ask for a document of the existence of which you don't know. How would that even enter your mind? The
reason that I'm spending time on this, counsel, is because the document explicitly says it's within the discretion of the committee that awards whether or not to award it, right? So if we assume that the document existed in 2020 and was the basis on which this was done, isn't that the end of your case?
Because we dispute that that was the basis on which this was done. First of all, they say they have the discretion as to whether to issue variable compensation at all. In other words, it's an all or none proposition. They can issue it or not.
That's not what it says. That may be your interpretation of it, but that's not the way I read it. It just says they have the discretion. In fact, it says more than that. It says that their discretion is as to any part of it, I believe. I think I read that this morning.
Well, they can't.
Am I wrong?
I believe they say they have the discretion to modify, amend, or not issue payments. My point is that in every year where they've never been a year where they haven't issued variable compensation payments, and in every year where they've issued them, which is every year, everybody who's eligible has gotten a payment. Nowhere does it say that we retain the discretion to deny the payment to a particular employee based upon our particular determination that that employee doesn't deserve it. That's the kind of discretion that would put it in a discretionary bonus perspective rather than an earned payment.
Except that it talks about risk. Seeks to appropriately balance risk with financial rewards.
In addition to which,
right? So it talks about risk, discretion to adjust payouts based on regulatory exams.
but nowhere does it say.
So somebody originates a bunch of loans that are too risky, and they say, we're not going to give you because you were too risky. Isn't that exactly what that's contemplating?
I don't believe it is. I believe it's contemplating that we can decide in any given year not to issue, and what the bank president said was, in fact, in 2020, we really debated it because of COVID, and we bought the stock of another bank, and we weren't doing so well. So we really debated not issuing them at all.
So it was within their discretion.
To issue it or not issue it. Once they make the decision to issue it, everybody who's eligible in that pool has earned it.
Except they made the decision after your client submitted his notice of resignation.
But he had already completed everything
And
necessary.
the plan says that if you've given a notice of resignation, you're not eligible to receive the award. So at the time they approved it, weren't they approving it just for the people who were eligible under the plan?
Again, that is, one, that's a requirement he was never aware of or told. Two, under the Wage Act, it'd be akin to saying to an employee who quit on a Thursday, our paychecks are issued on a Friday, you're not employed here anymore, you don't get your pay. So we don't believe that that
Unless it's
passes muster.
discretionary, whereas the hypothetical you just gave is non-discretionary. They owe him the money because he did the work. But if it's a discretionary payment, which is what this says, isn't that different? Do you have any case that says that something like this is a wage?
We believe the closest case and the one that's best analogized is the Israel case.
But Israel says that Judge Burroughs says over and over again, this is a commission as far as I'm concerned. It's much closer to a commission, right?
That's right. So you, under the Wage Act, you announce.
Is this a commission?
It's closer to a commission than to a discretionary bonus. It's something that was calculable, was earned. Once the bank decides they're issuing these payments on a bank-wide basis, he had done everything necessary to earn it. At no time was he ever told or disclosed that he had to be.
Burroughs said commission must be based on the sales or revenue generated by the individual employee, and I thought you told us this bonus wasn't based on that.
It was based, in Israel, they had the same three-pronged test or something very similar. And what they said, and what the judge said in Israel was, you can't say we're going to calculate these in the future and use that as a loophole. And I think the quote Judge Burroughs used was that not every ounce of discretion puts this into a discretionary realm, because that would allow just what's happened here, a loophole so that the bank can retaliate at its whim when somebody does something they don't like. That's outside the scope.
Well, Judge Burroughs, what she does, and it's actually kind of interesting because she divides it up and she really analyzes it at a pretty fine level. She says a certain component of this is payment for the work that he did and that he performed, the plaintiff in Israel. And a certain component of this is a little bit different. I'm not even sure that it's a commission, she says, because it's other people had done the work to sign these folks up, and then they'd left, and now the obligation to manage those accounts might fall on the plaintiff. And I'm not sure, but I guess maybe there's enough here to let that case go forward. Isn't that's basically what she wrote, right?
I agree.
Okay, but when she wrote that, she was writing it around the concept of a commission as being something that was earned, due and payable, because the work had already been performed. And so your argument under Israel would have to be that that's this case.
Yes.
That this is earned, due and payable for the work that he did.
Yes, he worked the whole year. His individual metric, he achieved a rating of over 2.9, which you have to do. His work under his individual portion of the metric generated a positive number. The bank actually calculated the number. It was 40,000. And the division goals calculated a number, and the bank goals calculated a number. That number, as of December 31st, was the number.
Is it a commission?
I think it's closer. I don't think it can be not a straight commission. I think if you look at what the Wage Act seeks to do, which is make something due that's calculable and due and payable and earned, it's closer to that than it is to a discretionary bonus.
Calculable, due and payable, and earned.
Determinable, I think is.
Due and payable. That might not be a bad definition. I mean, we have two words. We have wages and commissions. We know those have to be paid. Other than that, not clear what has to be paid, maybe nothing.
I think some benefits, Your Honor, but not sick time.
Well, that's right. The ones that are specifically identified, vacation pay and but calculable, due and payable, and earned. The problem you have is with the words due and payable, right?
Again, we say once the bank decides that it's issuing variable compensation to the bank, to its eligible employees, it's then due and payable.
Counselor,
I'm sorry, you're out of time, but Justice Ditkoff has a question.
Counselor, if you don't prevail on count 1 with us, are you arguing you can still prevail on count 2?
Yes.
Well, so the judge said that you conceded at the hearing on this matter that count 2 rises or falls with count 1. So considering you did that, how can you raise that argument now where you conceded below that if you lose on count 1, you lose on count 2?
Well, I think what the question was to me was, were the damages the same for the counts? And I think what I said was, yes, I mean, we're talking about the $40,000, the discretionary payments, although as I think about it now, there's obviously under the Wage Act the multiplication of damages and attorney's fees. But I think as a theory of liability for the breach of covenant and good faith, that this issue of this hidden secret policy in an undisclosed document after 17 years of making payments and the bank president's comments about not paying people who go to competing banks, that there's a basis for liability on that prong.
But what do we do with the judge's determination that you haven't preserved this?
Well, I mean, that was oral argument. I mean, she asked me a question in oral argument, and off the cuff, I said, yeah, I think, the damages are the same on the 2 counts.
All right.
Okay, seeing no further questions, thank you, counsel. Very well briefed. Appreciate the argument. Thank you.
Thank you, Your Honors.
Good morning, Your Honors. Michael Lewis for People's Bank. This case is fairly straightforward. It's what is the actual payment? It's not a commission that followed sales. It's a 1-year bonus that's conditioned upon board approval and employment at payout. And Massachusetts draws that line quite clearly. You can see in case law with SULLIVAN and Roma, it teaches that profit sharing and annual incentives do not fall within the Wage Act's commission clause. A commission is a percentage of sales or price or revenue that an employee generated.
Israel goes a little bit further, and I understand Israel's not binding precedent on this court, but Israel goes a little bit further and sort of gets at the gist of what has been done and what is being done. Doesn't this fall into that category of somewhere between a straight discretionary bonus and a commission?
I think it is difficult to always pinpoint everything and just fall them into one category, but I think Israel's actually a very good case to use and to support our argument. Israel mentions a commission over 60 times throughout, and it gives the definition breaking them down. We can see it was a monthly payment that calculated, and I'll quote it, calculated as a share of the revenue he generated. And then it used another example contrasting a once yearly bonus based entirely on remaining employed. And that's what the case is here.
Is it? Well, one. Go ahead.
No, you go ahead. I mean, contingent on him being, still being an employee. I mean, just because I'm bothered doesn't mean that that's the law, but I'm a little bit bothered by the existence of this policy that, as far as the record shows, no one's seen, no one's heard of. The guy's worked there for 17 years and doesn't even know it exists. I would be concerned that an employer can get around the Wage Act by simply having this sort of, backdoor policy that anyone can ask for, but no one's ever seen, or at least as far as the record indicate, no one has really seen. Perhaps you can explain to me why I shouldn't be bothered by that.
I think it's fairly common in employment matters where there are numerous different policies and you're not thrown a stack of 60 pages when you start the job, but at any point if you say, can I see how my bonus is paid out, you ask the HR and they produce a document.
I'm not sure I understand that, but I'm not sure in an employment context I've ever seen one like this where the record indicates that no one's ever seen how the bonus, again, maybe someone has, but or as far as the record indicates, it's available upon request, yet no one's ever seen it or requested it.
Is that the record? No one, there's no evidence in the record that anyone has ever requested it or seen it?
It wasn't asked if anyone had ever requested it. Without having my clients here to ask them right now, I don't know if anyone has requested it in the
We're
past.
asking about the record.
The record is it wasn't requested. But it was available at any point.
The record,
same with
are you saying the
numerous
record
policies.
says it wasn't requested, or just no one asked whether it was requested?
One more time, I'm sorry.
It sounded like you said the record says that it was never requested by anyone, or are you saying that there just isn't any evidence on whether anyone ever requested it?
From my understanding, the plaintiff did not request.
No, it's not about the plaintiff. See, if
Anyway.
I were discovering this case,
Sure.
and you were taking the position, hey, if all you have to do is ask, I'd say, well, did anyone ever ask? Did you ever provide this to anyone? Were those questions asked?
I don't believe they were asked.
Okay.
I mean, isn't that sort of, assuming there's a contract here, isn't that kind of what the breach of good faith and fair dealing gets at? I mean, for 17 consecutive years, someone who's hired with the understanding that they have potential for the bonus, and the potential has effectively been interpreted over 17 years as long as you meet these numbers, you get the bonus, or commission, or whatever we want to call it. And then after 17 years, it's, oh no, we have this policy that, oh, no one's ever asked for, as far as the record indicates, no one's aware of, so you don't get the fruits of your labor and the fruits of the contract because you're leaving, even though that wasn't an understood term of the bonus.
I think there's a few pieces to break down there. To begin with, I don't believe it was a contract or an implied contract.
Well, I said assuming that
To assume
a
that.
contract exists.
So we have two gates that need to be broken first. The first gate is there needs to be board approval. At any point, the board can modify, adjust, or change. Just because they haven't in the past doesn't take away that gate. I mean, in fact,
Was that known? The board approval is part of that, let's call it the hidden document, right?
It was, yes.
Okay, go ahead.
And to
It's a circular argument. It's a complete circle.
How so?
Because
That's what makes the promise illusory, but go ahead.
you're relying on a document that as far as we know, no one had ever seen.
I don't believe he was.
It's a great document. It uses the word discretion. It says we don't have to pay it. It's a level. You don't have to. If you're not here, you don't get paid. The problem is, we don't know if anybody's ever seen it. This guy's been here for 17 years, and every year they pay him. And then he leaves, and they say, oh, no, we have this document over here that says you don't get paid anymore.
I think the burden does fall on him to actually look into his own payment plan, however, if he wants to know how he's going to pay it. He's leaving at the end of the year expecting his bonus. The burden's on him to actually look at the documents. He can go to HR at any point and say, can I see how my bonuses are paid out? I don't think the burden falls on the bank to make sure that he understands everything involved.
Is there a legal obligation on HR to provide the document?
Not to my understanding. I haven't seen case law that reads that. I think of it as, I'm going to use a very similar example then. We'll go to a law firm. They pay out bonuses to different attorneys. If an attorney laterals in January and the bonuses are paid in March, the attorney's not getting his bonus. I don't need to see that. I know that. I mean, it's fairly common with bonuses in most positions and in most jobs that if you leave before a discretionary bonus is given, you're not receiving that bonus.
Well, you put the rabbit in the hat.
I'm sorry?
Put the rabbit in the hat. Again, if you leave before a discretionary bonus is due, the word discretionary is putting the rabbit in the hat. You understand what I mean?
I don't.
Oh, because once you say it's discretionary, then of course they have discretion not to pay it. The whole question is whether it's discretionary or not. That's the question.
No one knows
I get
it's
it.
discretionary until the document that no one's ever seen comes to light.
Well, even so, let's assume let's bypass that document a little more. If we actually look at the case law, the difference between a commission and an actual bonus, it's quite clear this falls closer to a bonus than it does a commission. I mean, a commission is a revenue.
So I may grant you that, but let me ask another question. There's three prongs to the way this is described, right? And one of those is based on individual metrics, right? Aren't those close to a commission?
The commission is more to do with a sale, and then it's paid instantly with that particular sale.
He's a senior VP of commercial lending, right?
So
was the metric how many loans they made?
That's still more
Was the
performance.
metric how many loans
piece of it.
they
It
made?
was, yes.
Okay. Why isn't that very much like a commission? If you make a certain amount of loans, sales, you'll get paid extra. For purposes of 2020, in this calculation, which everybody seems to agree on, doesn't seem to be disputed, so let's assume it's undisputed unless you tell me otherwise, $40,000. There were three components. Was one of those components his individual metric?
It was.
Okay, so he met his individual metric and he would have got paid something had he stayed till the end of March, assuming that the board granted that. So why isn't that like what Judge Burroughs describes in Israel as being a earned commission?
Meeting a metric is still a difference than a percentage of what you just sold, which is instantly going to be paid out. To go back to my example, we'll use billable hours for an attorney. Certain attorneys have a billable hour threshold. That doesn't mean you're automatically receiving your bonus because you hit your hours. There's going to be other things attached to it, such as board approval, remaining employed. There are two separate things between just, again, a percentage of what you generated and meeting a threshold.
It's not due and payable simply because he met the metric. That's the argument.
Correct. I think case law really expresses that quite well.
Under the plan, if the plaintiff met his individual metrics, let's say fell short on the other two, would he have been entitled, assuming he hadn't left and it wasn't discretionary, I know those are big assumptions, would he have been entitled to a portion of the $40,000?
Assuming well, again, we're still going to board approval. This is different than...
I said assuming that document doesn't exist for the sake of argument. If he met his individual number, that metric 1, but didn't meet metrics 2 and 3, would he have been entitled to a percentage of that $40,000?
No, he wouldn't have been. Again, we're not looking at a percentage of sales, which again will go to
I understand that.
To commission. For this, he's just meeting a metric. That doesn't instantly state, okay, you receive a portion of your bonus. That's not how the bonus plan was laid out. The bonus plan is laid out is at the end of the year, based on your performance, the business's performance, we're going to determine where we are, the board will discuss, and then you can receive a bonus from there.
Right, but there's 3 separate categories, and my understanding is that one of those categories is in effect based on his individual metrics, his individual performance.
These are all 3 considerations toward your bonus. They don't specifically lay out.
Not at all.
There's this formula.
Yeah.
There's a formula that calculates the bonus. And we're trying to understand how, if we're giving a formula bonus like everyone but him got, how is it affected if he doesn't meet all his individual goals? Does he get nothing? Is it reduced? How does the formula work as far as individual goals?
To be honest with you, I'd have to look at that specific formula. I haven't thought of that scenario. From my understanding from my clients is if all 3 pieces will still be board discretion, at any point it can be modified or changed. That's just giving the number that they intend to.
Okay, but Judge, this is not this hard. Judge Neyman just gave you the hypothetical where you take the discretion out of it. Assume that there's no discretion. My understanding is it's a calculable number. At the end of the year, you calculate 3 different components, whether he met his his baseline. It's like there are three pieces to it, the third of which is stretch. And if he meets that, he gets it. That's my understanding. Am I wrong?
If we're going to assume those two other gates don't exist, then yes.
Right.
But
So
they do.
if he met his individual metric, okay, forget about the other two, he would be entitled, assuming there's no discretion, he would be entitled to whatever that payment is, 9%, right?
Yes,
Okay. And he did meet his individual metric.
he did.
I gather people didn't generally know how their bonuses were, people didn't generally have the formula, is that right?
Correct.
General employees did. I mean, someone obviously did, because there was someone who calculated it, but that wasn't something that was common knowledge.
Really? They didn't give them their metrics at the beginning of the year? Say, this is what your metrics are? They must have. They must have said, this is what, here are the metrics.
I don't think the formula was
You're
given.
incented. It's an incentive program. You're incented to meet the metrics.
No, I don't think the specific formulas are provided, but yes, they did say you need to hit X, Y,
Here are
and
the
Z.
goals.
Yes, yes.
Yeah, I think it's listed at Exhibit A. Okay. It's at Record Appendix
They often do this.
17. Record Appendix 1.
If there are no more questions, I have nothing else.
Seeing nothing further, this is a very interesting case. Well-argued, counsel. The case is submitted. Thank you.
Thank you.
Calling our final case, docket 24P 1086, Woodward versus Department of Public Health. And good afternoon, counsel.
Good afternoon, members of the panel. May it please the court. My name is Eric LeBlanc, and I am here representing Lauren Woodward. Your Honors, an affirmative defense is one that must be proven by the defendants. Here, the lower court erred by turning that standard on its head at summary judgment and actually requiring affirmative proof from Ms. Woodward relating to the Massachusetts Equal Pay Act's affirmative defense of a self-evaluation. In fact, the lower court said that Ms. Woodward needed to give evidence of bad faith relating to the evaluation, and she needed to make a showing that reasonable progress was not made towards improving pay based on gender lines.
Isn't that how it works? Once the moving party makes their showing, that the other party has to come up with evidence that contradicts it?
No, and that's my point. Under an affirmative defense, the burden lies with the defendant to make an affirmative showing that these items occurred.
Right, but assuming they've done that, then it switches to your client to show there's a dispute.
I would agree, but they didn't do that in this case.
Is that true?
Excuse me?
As to which of the three components?
As to all of the three components.
As to all of them. All right, well, let's...
Yes, Your Honor. The first component is that this review and reasonable progress must have been made within the previous 3 years of the date of the filing of the complaint. In this case, the complaint was filed.
Didn't they put in evidence that they did it?
They did not put in evidence that they did it. They put in a spreadsheet saying that this all needs to be done by November 25th.
But didn't Carol Cormier in her affidavit say it was completed consistent with the guidelines, which include the time?
She did not include the time.
No, she said consistent with the guidelines, and one of the guidelines is the time, right?
Well, we know that's not true based upon the record, Your Honor, because the guidelines say that is to be submitted by November 25th. We have an email in the record, which is dated November 27th, saying that there are still outstanding items. So there is no showing of that date. There's also no showing of the reasonable progress.
Do you think a jury could infer that it was completed within 3 years?
Not, well, a jury may be.
You think no jury could infer it?
No, I think a jury may be.
Okay, so if a jury could infer it, they've put in their evidence. What's your evidence that contradicts the notion that it was completed, which is what you're saying? You're saying what they didn't show that it was completed. What is your evidence that contradicts that it was completed? If a jury could infer that it was completed from the evidence they put in, Now the burden shifts to you, as the questions came from my brothers, the burden shifts to you to identify evidence from which a genuine issue of material fact would be established on the issue of completeness.
Well, Your Honor, a jury could make such an inference, but at summary judgment, that inference goes towards the non-moving party's favor, not to the moving party's favor. So again, having not made the showing, the inference does not get applied back towards us.
Having not made the showing, they made a showing.
They did not make a showing of a date by which it was completed, which is a requirement of the defense. It needs to be done within 3 years. They did not make any showing that it was completed within 3 years.
So, I'm sorry, that begs a question for me. You were just asked about the Cormier affidavit, and as I understand your argument, you are not arguing that the Cormier affidavit was inadmissible or inadequate, but rather you are arguing that it should be disregarded because, number one, it is conclusory and self-serving, and number two, because it contradicts the 30B6 witness's testimony. Am I correct in my understanding?
You're correct on both of those points.
Okay. So you didn't move to strike the Cormier affidavit, correct?
Correct.
You didn't file a counter affidavit?
Correct.
Okay. So let's start with the 30B6 deposition. And I know it's summary judgment, so we review de novo. We're not bound by what the judge said. But the judge said that the 30B6 notice really didn't ask the specific question about this self-evaluation. Why is the judge wrong?
Your Honors, if you look at the 30B6 notice, which is located at the Record Appendix 723 to 724, it goes through the categories which we submit would have put the 30B6 directly at issue. I think the most important one is number 24, which is any and all pay equity review requests made to DPH and or Bourne between January 1st, 2015 to the present. That would encompass any pay equity reviews that were done within the organization from January 15th to the day of the deposition.
What's the exact language?
The exact language is any and all pay equity review requests made to DPH and or Bourne between January 1st, 2015 to the present. And in this case, Your Honor.
And the self-evaluation is a pay equity review request?
Yes. That's the only, again.
To DPH by who?
Excuse me?
Made to DPH by who?
It was made to DPH by the larger Office of Human Health, HHRS, as in the record. Again, with regard to, just to answer Justice Englander's questions directly, the pay equity review, the language of the statute is self-evaluation of pay practices. It's one and the same. I think they can be used interchangeably, particularly when used in any and all pay equity review requests made to DPH and or Bourne between January 1st, 2015 to the present.
You know, I mean, we would prefer not to decide a question like this based on the nuances of a 30B6 notice. The larger question is, what discovery was taken with respect to this self-evaluation that was conducted in November?
Understood, Your Honor.
And my take on this is, it really wasn't discovered.
And I would respectfully disagree with Your Honor.
Okay, so there's somebody who testified as to what was done, what the parameters were.
Yep, and it's cited in our brief, and I'll go through it for you right now, Judge.
Well, you got to answer this question for me then, if that was the discovery. What happened when they reviewed your client's situation?
Nothing. Zero things happened, despite the fact that my client had been complaining for years of pay inequality.
But in other words, during your review, you reviewed all pay equity issues, and they said yes. And you said, did you review my client's situation? And the answer was no. Is that right? That's what's on the record?
The record is my client had asked for pay equity reviews for years prior to this formal pay equity
got that part.
At the point where this pay equity pay evaluation was looked at in November.
Yeah.
The steps that they went through are as follows, and it's located within the documents. First, the initial review. They look at whether or not there are men and women in the same job. Here, we have Ms. Woodward, Mr. Pettigrew.
I get all this. I want to know what happened. What is the evidence of record as to what happened with respect to your client?
They did not find a pay disparity.
Why?
We don't know.
Did you ask?
We asked and we received information relating to all of the items that we've put into our briefing.
Who did you ask the question of? Who did you ask the question of why didn't my client appear on this spreadsheet of 8 names?
We asked the Ms. Gino in her 30B6 deposition.
Where did you do that?
It's in the record. I don't have it off the
And what did she say? What is the evidence of record as to why your client was not included in an analysis of the pay disparities associated with this ERA review?
We didn't have an answer because Ms. Gino wasn't prepared to testify.
So we don't know.
What we, Your Honor, I think we have to look at if we're going to look at the particulars of my client as opposed to the generality of the pay equity review, which is what the requirement of the affirmative defense is, then that's what our focus was on the affirmative defense.
So you lost me. Let me tell you why you lost me.
Okay.
Okay? Because the second issue is they have to show good faith.
Correct.
Right? They have to show it was completed in good faith and that reasonable progress was made. And your argument, as I understand it, with respect to good faith is, look, they didn't do anything for my client.
Correct.
So my question is, what did you discover with respect to what they did with your client? That's my question.
We discovered, Your Honor, that at the time that my client's pay was set, they failed to give her credit for
I get all that, but in the reviews, counsel, I don't understand why we're talking at cross purposes, and maybe it's my mistake, and you can correct me, but their defense is based on the review they conducted. When they conducted that review, I can't see how it didn't surface your client as somebody they should deal with, okay? Because your client is a woman, and she does the same thing as 2 men, and she gets paid a lot less than them.
And Your Honor.
And so my question is, when you did your discovery, what did you find out about what the review said with respect to your client?
We didn't view the fact that there was a disparity as being in dispute, nor was it disputed in the summary judgment record. We didn't think that we needed to understand that, because what we're looking at is a situation where...
You can't make an argument that they acted in bad faith without understanding that.
But we don't have to make an argument that they acted in bad faith. It's an affirmative...
They did not act in good faith.
But again, we don't have to make an argument that they didn't act in good faith. They need to prove good faith.
And they put in all kinds of evidence that they acted in good faith.
But the evidence that shows that they didn't act in good faith is exactly what Your Honor is pointing out. They did not look at my client, who had a clear pay disparity with the exact same title, with the exact same duties and responsibilities.
Stop. How do we know in the record that they, quote, did not look at my client? What is the evidence on that?
The evidence on that is the fact, when the inferences are taken in our favor, that they did not find a pay disparity despite the fact that my client had been complaining of a pay disparity for 5 years, despite the fact that they did not credit my client for her experience that was put on her resume, despite the fact that they did credit the experience of the males. That's not a good faith undertaking. And then when we move to the second prong, Your Honor, the reasonable progress towards eliminating gender pay differentials, my client's pay was never changed. That's not reasonable progress. What we went through with them there is they said that we needed to get...
You seem to be saying the defense doesn't apply unless the evaluation resulted in your client getting the pay raise, in which case I'm not sure what the defense does.
No, it doesn't. In this situation, Your Honor, we find ourselves I think in a different situation. The affirmative defense is only triggered when there is a pay equity issue at play. defendants didn't take the position underneath that there was, they didn't dispute that there's a pay equity thing at issue, but they did dispute that they didn't find one during their investigation. So we have a differentiation.
I'm reading from the statute,
Good idea.
is a self-evaluation of an employer's pay practices the same as a pay equity review request?
We would submit that it is. I mean, there's no
Pay equity review request would be your client goes to them and says, I'm not being treated fairly. I want equal pay. Take a look at this.
But
a self-evaluation is different. It's a process that is engaged in based on the statutory language. So I'm trying to figure out why topic 24 covers the self-evaluation. Do you understand my concern?
I do understand your question. And if you look at number 23, I think it is instructive. Any and all documents or communications related to Ms. Woodward's request for a pay equity review.
That's her request. That's
Correct.
different than a self-evaluation process. I mean, you said you were concerned about the affirmative defense. Why didn't you just parrot the language of the statute if that was your concern?
Because we wanted to encompass all potential pay equity reviews.
You want it to be broad. Okay, I understand.
Here's what I don't get. So they did the self-evaluation, and it ended maybe 2019, maybe you say it was 2020, but more than 3 years ago. Why didn't your client wait till 2023 and then sue again?
She sued in 2020, I believe, Your Honor.
I understand, but so they say, the judge says, hey, there's this defense, but the defense only lasts for 3 years.
Yes.
So why didn't she, I mean, she didn't do it in Suffolk, I checked. Why didn't she file a new lawsuit? Is there some reason why she can't?
Excuse me, the male comparators no longer work there.
Oh, interesting.
So you lose your opportunity.
Yeah, no, I get it. That's, okay.
I'm happy to continue going if there are any other questions, and I understand my time is up, so.
Anything further? Anything further? No, this case is well briefed. We understand your arguments, and Justice Englander may have another question.
No, we've got to hear from the others, that's all.
Okay.
Thank you.
I stand corrected. Thank you very much. Well argued.
I bet he'll have questions, though.
We might have some more questions.
And this is Attorney Sento.
Thank you, Your Honors. May it please the Court, Patrick Sento, Assistant Attorney General, on behalf of the appellee, the Department of Public Health. There are a few things that I'd like to address out of the gate in something that I believe one of the questions hit on very well, which is that the essence of Ms. Woodward's argument is that the affirmative defense is only available at summary judgment if the amoeba plaintiff is identified in a self-evaluation as suffering from an impermissible pay disparity. That's how I understand their argument. In such a situation, there would really be no need for the affirmative defense because, in theory, the plaintiff's claim would be addressed and mooted.
Well, it would eliminate back pay.
Potentially, yes. But I think
I think that's what his argument is.
Well, then that's the argument.
I think the argument, I'm going to make the argument. I think this is the argument. I think, and you responded it by saying, oh, that's a big circle. That's the way you responded to it. I think his argument is, look, you say you did the self-evaluation. Mm-hmm. Look at the facts of my client's case. Sure. My client is a woman who works with two men and gets paid a lot less than them for doing the same work. Therefore, one would think that it would have come up in the self-evaluation. However, it didn't. That's my understanding of the argument, except the it didn't part, I'm not so sure of, because I don't think there's any evidence on that.
So what I can, that's well taken, and I appreciate that. I don't disagree with that. I think the evidence shows that the self-evaluation guidelines state that all bargaining units in the Department of Public Health were evaluated. So I would say that it can't be disputed that her position was a subject of the self-evaluation. But what is really important here, and I really want to hammer this home today, is that the only way the affirmative defense makes sense is when it is viewed independently of any specific MEPA plaintiff's claim, the merits of any specific MEPA plaintiff's claim. And what I would point the court to two things that make this crystal clear is that the language of the affirmative defense assumes that a good faith self-evaluation could turn up no individuals who were impermissibly underpaid. And that's clear.
Okay.
So I think if it assumes that nobody could be, if the affirmative defense could be applicable.
Assumes that the result
Sure.
could be
that nobody was.
we don't have pay equity issues. The
Right.
result could be.
Right.
But, there was a point at there where you sort of said, well, I think that she was included. I'm going to tell you right now, if she wasn't included, you don't get the defense.
We don't dispute that.
All right?
We don't dispute
well,
that.
and there's no way that could be right, right?
Understood.
Okay. I mean, it could not possibly be that you could defend yourselves by saying, we looked at the pay equity. Of course, we ignored hers.
Of course. Yep, absolutely. And the AGO guidance, I believe, states that, so that we agree. The AGO guidance.
But then that leads to this question of you had to do it in good faith, right? So you can't exclude her either because, she's been asking for a pay equity review for the last several years, right?
Sure.
Okay, so that gets me back to my question. What does the record show with respect to what it said about her?
The record is clear, and the guidelines here, which explain how the evaluation was prosecuted or put into effect, makes clear that all bargaining units within the agency were reviewed, and only those individuals who were determined to be, under MEPA specifically, determined to be subject to an impermissible pay disparity were identified in the results. And there were 7 of those individuals in the final results. Ms. Woodward,
what happened with her?
She was considered, and it was determined that she wasn't subject to an impermissible pay disparity.
And there's a document that says that somewhere?
There's
an analysis that says, yeah, she's making 20% less than the males who are doing the same work, but turns out that there's a good reason why they're getting paid a lot more than she is, and therefore there's no problem?
There's
a document that says that?
We don't need it, and I'll explain why, respectfully. It is the only inference that can be, it's not a favorable inference, it's the only inference that can be drawn from the record, when the record states that all bargaining units, including Ms. Woodward's, were reviewed, and only those believed or suspected to be suffering under an impermissible disparity were identified. Now, it can't be the case that, because these self-evaluations are performed necessarily prior to any litigation commencing. It can't be the case that to avail oneself of the affirmative defense, the employer has to have an explanation for every single individual that was subject to the self-evaluation, especially in with an employer like the Commonwealth, which is thousands of people.
Getting back to the concrete, the way I understand this, HR sent to the agencies, well, here are some people with the same title who have different pays, and explain why. Or determine whether that's for a permissible reason or an impermissible reason. If it's impermissible, send it up. Is that right?
Yes. Yeah, I think that's a fair assessment.
So presumably, Ms. Woodward and the 2 men get sent back to the agency, and then the agency says, no, this difference is acceptable, presumably because of the experience.
Correct.
But we don't have that. That's what I'm deducing. It's not actually in the record.
And it wouldn't be for anybody. That's correct. And that's not a requirement.
I understand that it wouldn't be for anybody.
For any of the individuals who are, for the vast majority of the individuals who are determined not to be laboring under a disparity made impermissible by MEPA, there is not going to be anything in the record that would explain why, and the affirmative defense doesn't require that. That's the thing, is for this affirmative defense, and this is obviously a case of first impression, but for this affirmative defense to have any practical effect and to have any teeth, there has to be a certain amount of discretion given to the employer, and I don't know how else this could have been designed to and implemented to satisfy the good faith.
Golly, I got to tell you, It's not selling to me. The facts of this case are fairly stark. She's sitting next to two men who do the same thing that she does. She's getting paid 20% less, and you're telling me, I get an affirmative defense, but I don't have to document why it is that that's okay?
She hadn't filed her suit when the self-evaluation...
Here, the facts that I just told you existed.
The affirmative defense does, I would...
You see what I'm saying?
I do, but I don't see as a practical matter how the affirmative defense, how a self-evaluation could be implemented in that way. But
Well, the way you would implement it is you say, if you identify any disparities, then you should document why it is that that disparity is an acceptable disparity. That's the way, it seems to me, if I were working for the government, I would run this program, because otherwise I would be subject to a claim that I did not act in good faith, which is something that you have to establish in order to establish the affirmative defense.
The problem with Ms. Woodward's argument is she is conflating the merits of her underlying MEPA claim with the merits of the affirmative defense. I would really like to draw the court's attention to the AGO guidance that is that we reference in our brief, and I believe my brother references in his brief as well, and specifically on page 17 of the AGO guidelines. This is what it says verbatim. It says that whether or not an employer is eligible for an affirmative defense does not necessarily turn on whether a court ultimately agrees with the employer's analysis of whether jobs are comparable or whether pay differentials are justified under the law, but and this is the key part of this quote, but rather turns on whether the self-evaluation was conducted in good faith and reasonable in detail and scope.
I'm okay with all of that. What I really liked was actually in the earlier part where it used the word analysis.
Sure.
See, what you're telling me is there is none. For this particular person, there was no analysis in the record, and I can't get past that. Let me ask another question, because unless...
Well, go ahead. I actually have two questions, but why don't you continue for now, please?
Oh, go ahead.
No, go ahead.
All right, I want to switch gears to reasonable progress.
Okay.
How did you establish as a matter of law that you'd made reasonable progress?
What I would say is that the determination that the 7 employees identified were subject to impermissible disparities under MEPA, sending that final set of employees up the chain to the Secretariat, at that point, reasonable progress had been
We have a relevant universe.
I'm sorry?
Do we have a relevant universe? So this leads to one of my two questions.
Sure. Could you...
So let's assume, for the sake of argument, hypothetically, what if it turned out that in Bourne, and I know this is a hypothetical, it's a stretch, but that's why it's a hypothetical. Let's assume there were 70,000 individuals who were subject to impermissible pay disparities, but only 7 of the 70,000 were corrected. Would that constitute reasonable progress?
So if there were 70,000, so could you rephrase it one more time for me?
Sure.
Or not rephrase it, I'm sorry, repeat it.
There were 70,000 individuals.
Yes.
Within Bourne.
Yes.
Who were subject to impermissible pay disparities. And only 7 of those were corrected.
No.
Would that constitute reasonable
Probably
progress?
not. Probably not.
So it's 7 out of how many? We know that 7 individuals were subject to pay disparity and had it corrected, right?
Correct.
7 out of what universe?
Actually, do we know they had it corrected?
We do.
How do we know that?
We know that because it's in the affidavit of Carol
Form your
Cormier.
affidavit. So let's assume, so what's the relevant universe? 7 out of how many?
7 out...
out of identified pay disparities, but without a relevant universe, how can it be said to be reasonable progress?
Well, I would...
I assume you're going to hearken back to your earlier statement that it doesn't have to be any, right?
Well, I think that's part of it. I think that is. But so I think the results of the process here is what is the critical part of the analysis. I would say that the results of the analysis are not dispositive of the question. But I would...
Why isn't your position that 7 out of 7?
Had their
No, I mean, I understand it's contested, but isn't it the position of your client that you fixed all the pay disparities you found?
Thank you for clarifying. That is right. That is our position. Well, impermissible pay disparities.
Impermissible pay disparities.
Right. So the 7 that were identified subsequently had their pay disparities rectified. So, but as far as what the DPH, the specific agency at issue here, under which Bourne kind of administratively lives, when they sent the results up the chain, it was out of the agency's hand. There was no more progress that the agency could make at that point. And in just a quick aside, there's nothing in the record to suggest that the self-evaluation was not complete from DPH's perspective as of November 27th. And the purported contradiction between Ms. Cormier's affidavit.
That's my next question.
Yeah.
So looking at topics 23 and 24 of the
Yes.
30B6, why did they not, why was the self-evaluation not responsive to those two topics?
Because it's very clear, the only way to read those topics is that they pertain to Ms. Woodward's pay equity requests. In the language in the written discovery record with respect to pay equity requests, pay equity review, requests for pay equity review, these are all specific to Ms. Woodward's request for somebody to look at her salary with respect to her comparators. The self-evaluation...
You're saying that's clear just contextually, or can you point to a particular
Contextually,
page?
absolutely. There is no reference in the 30B6 notice to affirmative defense, to self-evaluation, to any of these things. I think it's an unreasonable reading. But I would also submit that even if the court concludes that the self-evaluation was covered in one or more of those topics, it really isn't. It doesn't do much, if anything, for the Ms. Woodward's argument, and that's because Ms. Gino, to the extent she does testify to the self-evaluation, it's totally consistent with the documentary record, with Ms. Cormier's affidavit. So there really is no conflict or incongruity. But the 30B6 notice topic is kind of a red herring. What's important here is that the self-evaluation proceeded pursuant to really comprehensive written procedures and deadlines. It was concluded. And
you're out of time, but you can answer your question and you can check your colleague's note as well if you would like.
Oh, well, I appreciate that, Your Honor. Oh, the other thing I will note is that in interrogatory number 16, which is part of the record, and I believe it's on record appendix page 153, we ask for any facts as to why we would not be entitled to the affirmative defense, and there's no substantive response. It's an objection that was never supplemented in the record. So we've put forward the evidence that was available to us with the lack of any discovery into the issue from the appellant.
So Justice Ditkoff has a question, and then I believe Justice Englander has a question or questions.
So the concern I have, I mean, maybe you'll win on this defense, but it seems like someone got these names of these 3 people and said that this disparity is fine. When you've got a system that, as far as I can tell, and correct me if I'm wrong,
sure,
is set up so that your experience in stereotypically male jobs, like police officer and investigator, counts for your steps, and your experience in stereotypically female jobs, like nurse, doesn't count for your steps. And I'm having a hard time seeing how that isn't exactly what this statute is intended to fix. Am I missing something? That seemed to be the way it was calculated.
So I think I don't disagree that type of thing is what the statute was intended to remedy. However, that merits analysis of any specific individual plaintiff's claim is totally independent of the analysis into the affirmative defense.
No, I get that, but you might need to talk to your client about what they'll do if they ever have comparators again.
Okay.
Under the way they've designed their pay structure.
Understood. Thank you very much.
Talk about reasonable progress. So what Cormier's affidavit says is they were adjusted upwards. And,
They were.
And your opponent says, well, we don't know how much. We don't know whether those adjustments, we don't know whether it was $10 on a $2 million difference or, it was the entire amount. So, what do you say to that?
Well, again, what I would say is that the Commonwealth as an organization, as a complex, multi-agency organization, is a little bit unique as an employer. I would say that the agency here, which is the defendant, there was nothing else the agency could have done after finishing its part of the evaluation and then sending the results up the chain in substantial compliance with the deadlines.
Well, it has to make reasonable progress, though.
What's
You
that?
can't have the defense unless it makes reasonable progress.
Reasonable
progress.
Yep.
Is that a question of fact or a question of law?
I would say in this situation, given the record here, it's absolutely a question of law. There's nothing else DPH could have done. There was no more progress that...
Whoa, whoa. Isn't that a mixed question? I mean, who cares what DPH could do?
Mm-hmm.
If DPH couldn't remedy an obvious violation of the Equal Pay Act, then they're violating it. And they don't get a defense because, geez, we did everything we could do. That can't be right.
The legislature could very easily have said that a total elimination of pay disparities is required to claim the affirmative
that's not my point.
defense.
You're saying, we send it up the chain. If the governor doesn't give us enough money to fix it, we've still qualified for the defense. I say there's a legal question there, which this judge would likely answer not the way you would like me to, which is, no, you don't get the defense if you don't solve the Equal Pay Act problem, okay? So there's a legal question there about what is reasonable progress. Now, you started off, but there's also, I think, a factual question as to what is reasonable, which you usually would send to a trier of fact. Okay, what is reasonable? Now, you started off your argument on this issue by saying we satisfied it when we identified these 7 people. Well, what tells us that that's reasonable progress? We identify 7 people, but we don't do anything about it? How can that be reasonable progress? Is there some case law? Or are we really just talking about what is essentially a question of first impression as to what reasonable progress means?
I think that's in this case, in the context of the affirmative defense, it is a question of first impression. But what I would say is, it could be. Of course, it could be a question of fact given the record. But there aren't competing facts in the record to raise a genuine dispute on that issue. So on this record, I would submit it's a question of law. And given the way that the affirmative defense is written, it's a.
That record is we sent it up the chain and adjustments were made.
In essence,
That's
yes.
the entire record. On the subject of progress, the entire record is we sent 7 names up the chain and adjustments were made.
That's a very kind of summary distillation of it. But I mean, if you look at what the guidelines say,
What would you add to it?
I would add that the process set forth in the guidelines was followed after DPH sent its results up the record, and pursuant to those guidelines, adjustments were made.
And you want us to rule, your argument is essentially, as a matter of law on that record, we satisfied that prong of this affirmative defense.
That's correct, Your Honor.
Okay.
And seeing no further questions, I want to thank counsel for both parties. Well briefed, well argued. The case is submitted, and that concludes our session.
Thank you.
Thank you.
All rise.
Okay, yeah, you too.